Hello, everyone. We'll be starting shortly. Just want to give everyone a chance to log in before we officially start the program. Good afternoon. Welcome to Navigating Your First Appeal, presented by the Florida Bar Appellate Practice section, as well as the Government Lawyer section. I am Russell Kent, a senior attorney for the state of Florida, and the CLE chair and treasurer for the Government Lawyer section.
Good afternoon, everyone. My name is Bailey Howard. I'm an attorney at Bishop & Mills, PLLC in Tallahassee. I'm co-chairing this with Russell.
Thank you, Bailey. Following the seminar, you will self-report your CLE credits by visiting the member portal at floridabar.org and entering the course number for the seminar. The course number is 5534. I know that Bailey will be kind enough to repeat that later on, but we're thrilled to have such a great panel today, as well as everyone listening in. I also did want to let everyone know that this presentation will be available to anyone who wasn't able to see it on both the Appellate Practice and Government Lawyer section websites. So if you enjoy the seminar and want to encourage other people in your office to watch it, it will be available on our websites a little later on. At this time, I'd like to introduce the speakers for our first panel, both good friends. First of all, we have Courtney Brewer. She's a shareholder at Bishop & Mills and board certified by the Florida Bar and Appellate Practice. She is currently the secretary of the Appellate Practice section, as well as the president-elect of the First District Appellate American Inn of Court. She has co-taught the appellate advocacy class at FSU College of Law, a course I should have taken. And prior to joining the Mills firm, Courtney served as a Deputy Solicitor General for the Attorney General for 4.5 years, which is how I first met her. And she also clerked for Justice Charlie Wells at the Florida Supreme Court from 2004 to 2007. Her co-panelists will be Matt Canigliaro of Carlton Fields, who's also board certified appellate specialist and handles legal issues in trial and appellate courts across Florida and federal court and other states. I first met Matt years ago when we were tied together on an amicus issue. And of course, we somehow lost, but I still think we should have won. Matt's a frequent speaker in legal matters. And he's always one of the people that Courtney and I have speak at our Florida Supreme Court seminar, which fingers crossed will hopefully take place this summer. With that introduction, I'll pass it along to Courtney and Matt, and I know we'll be in good hands. Thank you.
Thank you, Russell, and welcome to everyone. I think our understanding is that we have a wide cross-section of folks attending today. Some folks perhaps rather new to practice, some folks perhaps rather senior, but appreciative of the opportunity for a bit of a primer or a refresher, and perhaps some government practice, perhaps some private practice, perhaps some, well, mostly with the state court practice, we would assume, but perhaps once in a while some federal appeals thrown in the mix. So we'll try to speak to a little bit that might appeal to everyone here. And I suppose I should say at the outset that certainly for the segment that Courtney and I are about to do, we're going to spend 30 seconds, 60 seconds on topics that could rightly deserve an hour-long discussion. So this is going to be a very light treatment to give folks what's really an introduction to what's going on here. And I think, from my perspective, one of the more appropriate ways to begin this might be to recall when I was first out of school and applied for a law clerk position with the judge at the 5th District Court of Appeal. Wonderful judge. She ended up hiring me, and her name was Jacqueline Griffin. When I went to interview with her, I sat down at her desk in her chambers in front of her, and you couldn't help but notice in front of her, or facing you as the person sitting in front of her desk, was a little sign. And the sign read, "Read the rule, fool." And I read that, and of course, just a kid out of school, I wasn't quite sure how to take that, and probably wasn't directed at me. It looked like it was there full time. But I did sort of at the end of the discussion say to her, "Judge, that looks a little harsh." And she said, "You would be surprised how much, whoever you are, how much time and attention and aggravation and thought goes into trying to understand what should happen in a particular case. And the answer is in the rule. Just read the rules. They've been put together by, very intelligent people, committees of people over great amounts of time, and are meant to be comprehensive. So as a way of beginning here, the first tip to everyone is read the rules. Know the rules. Know what rules apply and where to find them. And nowadays, we're talking about, of course, for appeals, the rules of appellate procedure. To some extent, the rules of civil procedure play in here too. And nowadays, we have the renamed rules of judicial administration, general practice and judicial administration, which is sort of a catch-all now repository for things that apply across practice areas or across trial areas or litigation areas or court areas. So really you need 3 sets of rules handy in order to sort of march your way through. And of course, if you're in a criminal court, it'd be the criminal rules as well. So 4, if you're criminal, you've got a set of rules that you've got to understand and master. And don't be afraid to just go back and look. I give a talk frequently on the rules of civil procedure for the Civil Trial Board certification course. And every year I do that, I go back and reread the rules. And without fail, every single time, maybe it just suggests I'm forgetting more than I should, I go back and reread the rules and I see things I think, was that always there? And that looks more clear than I remember it being. So I just encourage folks, read the rules. Now, if it is your role to handle an appeal, and maybe you're here because you haven't done too many appeals, this is new to you, maybe you're young as a practitioner, maybe you're quite senior as a practitioner, but haven't done appellate work. Where do you start? Like, what do you do? I want to suggest before you jump into, we need a notice of appeal, I need to be thinking about all the different aspects of the appellate side of the case. A good concern to have at the front end, anytime you are brought in to handle an appeal, is what is the current state of that order or judgment? Basically, is it executable? If it's a money judgment, can somebody go after your client for money? Are you and your client entitled to money? Give thought at the very, very beginning, because there's an overlap there. Sometimes appellate counsel assumes trial counsel is handling all things related to stays and bonds and that sort of thing. And sometimes trial counsel assumes appellate counsel will come in and handle things like stays and bonds. And for instance, if you represent a defendant who's taken a judgment, one thing you don't want to happen is to have that judgment be executable and nobody's thinking about that. Meanwhile, the judgment holder goes off and begins the execution process. And the next thing you know, there's a whole lot of trouble for lots of folks. So a tip is to remember, when you first get involved in appeal, consider the sort of state of the judgment or order being appealed. Is it executable? Do you need a stay? Stays are basically handled in the appellate rules, Rule 9.310. It addresses bonds as well. I'm not going to go into the details of it, but I'll just sort of suggest, staying at a fairly high level, that those are important considerations that are easy to overlook because folks jump right into the sort of mechanics of the appeal process itself. And there are some real pitfalls there for folks if that sort of thing isn't considered. So with that, Courtney, let's talk a bit about the nuts and bolts of how we go forward with the appeal.
All right, thanks, Matt. So yeah, it may not be the first step you take, putting together your notice of appeal and initiating the appeal, but the seminar is called Navigating Your First Appeal, and you ain't going anywhere if you don't put the key in the ignition. And that's really what the notice of appeal is going to do, is kickstart your appeal. And I will be so bold as to say that this might be the most important, or at least this section of the presentation might contain the most important tidbit you will hear all seminar long, because we are going to talk about the one jurisdictional thing there is in an appeal. Now, there are lots of ways to muck up appeals, but often appellate judges have the discretion to forgive you transgressions. They may not, but they can, if you get your brief filed late, or even if you, God forbid, miss an OA or say the wrong thing at an OA. But missing the deadline for your notice of appeal is something that no one can save you from. So that is why I will make that bold statement that I am going to address the most important thing you may hear today. So before you file your notice of appeal and put it together, you need to really determine whether you can appeal. And like Matt said, there are lots of topics we're going to cover that deserve their own hour, if not their own seminar. And I think whether an order is a final or a non-final order, you can look through Lexis and Westlaw on this and see all sorts of case law about it, because there's a lot to discuss. But for your rule of thumb, quick and dirty 30-second rule, final orders are those that end all judicial labor. So if you get a verdict and the trial court enters the judgment pursuant to that verdict, and usually it has to have words of finality. It does have to have words of finality in it. So go hence without delay, let execution issue, or if you've moved to dismiss a case and the court has granted that motion and says, the case is hereby dismissed. Those are the type of words of finality we're looking for in order to tell if they're a final order. If it is final, it's immediately appealable. And the rules of appellate procedure, if it's a civil case, it's under 9.100. If it's non-final, it's still possibly appealable at that moment. It needs to be listed within the appellate rules. There's a rule for criminal appeals, and I believe that those are contained under 9.140. 9.130 is where, if you're on the civil side of things, you would find the rules that are immediately appealable. And these are the types of orders that you don't want to have to go through a trial before an appellate court resolves it. So things like jurisdiction of the person, things like immunity, like workers' comp immunity or sovereign immunity, those may be immediately appealable. If you have a non-final order and it's not on the list of non-final orders you can appeal, you may still be able to seek review, but that's by filing an extraordinary writ petition as an original proceeding. And again, the topic of an entire other seminar. So if you are going to be filing a notice of appeal, I'm going to talk about 4 key inquiries you need to think about in preparing your notice of appeal. And that is what to file, where to file, your filing fees, and when to file. As far as what your notice of appeal should contain, like Matt said, we have rules of appellate procedure for that, and they very specifically spell out what a notice of appeal needs to contain. The names and roles of the party, the name of the court to which you are appealing, the date of rendition, and the nature of the order. And sometimes you might want to consider looking at the DCA's website to see if they have any particulars about what they want included in your notice of appeal. Because at the first DCA, in the notice to attorneys and parties, they would also like you to include the name of the trial court judge. None of that is, if you forget the name of the trial court judge, no one's going to keep you from appealing or say that your notice of appeal is so defective, you've lost the right to appeal. But it looks good if you get all the information that the court wants you to get in there and you don't have to file an amended notice. I'd also note, Matt talked about the rules. There's also forms for that. In the back of the rules that I think they're designated as Rule 9.900, there are a series of appellate forms, including a notice of appeal and some of the other documents we'll be talking about that you can look to and are helpful in preparing your notice. You usually want to attach the order for which you are seeking review. That is not the case in criminal cases in state courts, but otherwise, if you are appealing a final judgment, even if your only issue on appeal is going to be the order that the trial court denied your motion in limine back pre-trial, you're still going to be attaching the final judgment, because under the merger doctrine, all of those pre-trial orders, all of the orders that happen merge into that final document. Of course, if it's non-final, you're going to want to attach the order that you are actually appealing. Where should you file your notice of appeal? In the court from which you are appealing, in most cases. If you're in an administrative appeal, you also have to file that notice at the DCA. But in the classic civil case, you're going to file your notice of appeal at the trial court, and then it is up to the trial court to transmit the case over to the DCA. And that's when you're going to get your appellate case number. And from then on, most of the documents you'll be filing will be in the appellate court moving forward. Serve your notice of appeal, of course, on all parties. Filing fees. Just a quick brush on this subject. You always want to check with the courts to be sure what filing fees you need to pay. But the rule of thumb is there's going to be a filing fee. And of course, if you're doing a government appeal, this may not apply to you, but just so you know, for future reference, you need to pay a filing fee both to the trial court and to the appellate court. And those should be payable via the e-portal, but you just want to make sure you get those paid. A lot of times you'll pay your trial court filing fee right away, and then you get an order from the DCA once the case is assigned a number there saying, gosh, what are you doing? Your whole case is going to get dismissed if you don't pay your filing fee here right away. Those are pretty classic orders. Don't let those scare you. Just pay your filing fee.
I think they try to scare you.
Yes, well, they want to make sure you meet the deadline. So just make sure you meet the deadline, but they won't do anything before it. And speaking of deadlines, here we go. The most important takeaway for everything that I'm going to blather about today is the deadline for filing a notice of appeal. Remember this, if nothing else. Your rule is 30 days from the date a signed order is filed by the trial judge with the clerk of court. With a few exceptions, and there's some really fun ones, especially in the criminal cases. I know the state, when the state is appealing a criminal case under the state rules, they have less than the 30 days. But if the government is appealing in the federal under the federal rules, they have more than the 30 days. So, like Matt said, always check your rules. But rule of thumb, 30 days from the date the signed order is filed by the trial judge with the clerk of court. If you file it on day 31, if you file it 1 minute past the expiration of day 30, whatever your reason, whether your whole computer system's shut down, your assistant who files these things for you got COVID at the last minute, like there is nothing that can save you on this front. So for that reason, if you don't have to wait till the 30th day. And so if you have any question in your mind, the order came out on a Friday, should I have started counting on the Saturday or on the Monday after for the 30-day period? Go with the earliest time that you come up with, or even earlier. You're going to hear about how the notice of appeal deadline really triggers the rest of the deadlines in your case. So you don't want to cut yourself off too quickly on your briefing deadlines, but I would just make sure that you get your notice of appeal in timely. And so once you do that, Matt, you got to have something for the appellate court to look at about what went on at the trial court. So I will turn it over to you.
Yeah, let's talk about the record for a few minutes. But before I do that, let me me back up to sort of a big picture here. You'll hear, I'm sure, from later discussions that it's always good to give the appellate court a roadmap, and maybe it would help you all who are watching or listening today to get a bit of a roadmap to what we're doing. After Courtney and I are done, there'll be a discussion on briefing, and then there'll be a discussion on oral arguments. Then there'll be sort of a neat, comprehensive section that covers just a lot of different portions of the appellate process. What we're covering here really are the things that come before you start to write your brief. And let me try to address concerns involving the record. If you've been involved in appeals, you've heard references to the record. It's sort of a strange term because it's thrown around as if everybody knows what it is and where it is. And sometimes no one understands sort of what it is and where it is. It's just the record, it's the record, it's the record on appeal. Well, in many courts, in many cases, there is a thing, a physical thing called the record on appeal. Now that we are electronic, it's a little more not substantive in the sense it may not be physical, it may just be some PDF files. Before several years ago, when we went to all electronic filing and processes, the clerk of the lower court physically put together what was filed in the lower court, broke it into volumes, and then mailed it to the appellate court, and that was the record on appeal. Nowadays, we don't do that anymore. Filings are done by PDF. When the record is created for a particular case, it is created as a PDF file and sent to the appellate court as a PDF. So, but there is still a record. And if you've heard people say things like, well, if it's not in the record, it didn't happen, or if it's not in the record, you can't refer to it. Those are basically true. The record is the thing that the appellate court looks to understand what happened in the case. Now, there may be things you mentioned that are just within the case law or otherwise things that the appellate court can notice or know, but anything case specific as a general rule needs to be in your record. So when do you get a record and who creates it? The simple answer is you get a record in final appeals, and it's created by the clerk of the court you're appealing from. So the lower tribunal court, typically it's a circuit court in Florida practice, headed up to the District Court of Appeal. That's who creates the record. There are rules in the appellate rules that address the record. And one of the rules you'll see is 9.200, which has two 10-day deadlines that are triggered by the filing of the notice of appeal. One is to file what's called directions to the clerk, and the other is to file a designation to the court reporter, directing the court reporter to transcribe a particular hearing or trial. Those are 10-day deadlines, and they're triggered from the filing of the notice of appeal. The directions to the clerk are sometimes a little bit confusing. If you look at 9.200, it has in it what the clerk is required to put in the record unless told otherwise. So in my practice, and I think in the practice of many folks, the simpler thing to do is not to do directions to the clerk, because there is a default practice there in the rule that the clerk is to file in the absence of different instructions from counsel. So typically in my practice, when I begin an appeal, I'll file notice of appeal and I will not file directions to the clerk. There are some people out there who cannot resist, and they file something that says directions to the clerk. The clerk is directed to create the record on appeal, including all things set forward in 9.200, which is completely unnecessary because that was the rule anyway. The designation to the court reporter, that's a little more tricky. If you have a case that involved a trial or large evidentiary hearings or whatnot, that where you don't have the transcript yet and you need it, then there's a process set forth in the rules for getting those transcripts ordered. They have some time limitations on when the court reporter is supposed to finish and what is to be done, and sort of status updates if there are problems. So be careful to consult the rules on all that. But if you have a case where maybe your trial transcript was already done before the appeal, maybe it was done as the case was proceeding, as the trial was proceeding, maybe you involve an evidentiary hearing and you got that transcript at the time, and for whatever reason it was all done and now it's all filed. then you don't need to do a designation to the court reporter. So basically, you don't need to do any of that. The clerk of court will simply create the record, and it will be sent on to the appellate court under 9.200. That happens now about 60 days after the notice of appeal is filed, which is great because your brief is due 70 days after the notice is filed, unless you get lots of extensions. But the general rule played out means you're going to get a copy of the record. The clerk will finish, transmit that to the appellate court, and you will have access to it before your initial brief is due. That wasn't always the case in the rules. And if you talk to folks who've been practicing for a while, it used to be a lot more difficult to deal with the record and understanding what's in it and getting your brief ready with proper citations. But the way it works now is really very simple and very friendly. If you are registered for EDCA in the particular court where your appeal is pending, you can log in, and after the record is transmitted by the clerk of the lower court to the appellate court, you can log in and download it. It's wonderful. Just click, 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 and you have a copy of the record, which is just light years better than where we used to be in this practice. And it really does make things fairly straightforward. It is important to try to get the record right. If you have a very narrow appeal, you will see guidance. Some of it's in the case law, actually, from some judges who've said this. And you'll see it elsewhere too, that if you have a very narrow appeal, you don't need to give the appellate court in the record a whole bunch of things that just don't matter for your appeal. I'll confess that in my own practice, that never happens. I'm never quite certain what the appeal will involve or not involve. And I tend to just err on the side of let's get it all in there. Are there times there's an exception to that? Perhaps. The rule does provide for correcting. If you need to correct the record later, it happens all the time that you get involved in a case and you later learn that there's something, perhaps something that was maybe used in the trial court, but nobody filed. And so you actually have two problems. One is that the thing you want to refer to was never filed in the trial court. And because of that wasn't included in the appellate record. So you need to correct that by getting it filed and then asking for the record to be supplemented just under the terms of the rule. There are cases, non-final appeals, for instance, and writ proceedings where there is no record created by the clerk. And in those proceedings, the appellate court will work from an appendix. Now, you can have an appendix in a final appeal, but in a final appeal, when you have an appendix, it's really just your selection of items that you want to give to the appellate court in a separate document, maybe a smaller, tighter compilation of the things that you think matter in the appeal. In a non-final appeal, in civil cases at least, and in writ proceedings, certiorari, et cetera, there is no record created by the clerk. You create the record in the form of an appendix. Now, there is an appendix rule, it's 9.220, and it has now numerous requirements in it for how the appendix is to look. Perhaps the most peculiar is, or at least not intuitive, is that the appendix has to be consecutively paginated, beginning on the cover page as page 1. Basically, the appellate judges are using the PDFs that you file, and they want the page of the PDF to match the page of the appendix. So if you say something is at appendix 222, they want to go to page 222 of the PDF. So the rules now provide for requirements involving pagination, bookmarks, and a bit about making sure you have an index and a certificate of service in there. So in cases that don't involve a record, the appendix becomes essentially the record. A quick word or two on what should be in an appendix or even in the record. Things that should be in the record and in an appendix are things that were in one fashion or another in front of the trial court. Every once in a while, you get some rather heated troubles over folks trying to drop into an appendix or file into the record things that really weren't in front of the trial court when these decisions that are being appealed were made. So as a general rule, keep in mind that what you need to give everything to the appellate court they're going to need to make the decision. But particularly with an appendix, but even to some extent with the record, these should be things that were in front of the trial court when the decisions that you're challenging were made.
All right, Matt touched on it briefly about motions to supplement the record, but I'm going to talk kind of generally about motions because sometimes you need to talk to the appellate court because we're lawyers. There's going to be arguments. There's going to be things we need along the way before we get into the substance of the case with briefing. As far as what you need to put in your motions, here the appellate rules maybe aren't crystal clear because there aren't really a lot of requirements. I mean, my advice to everybody out there is be very clear about what you want. Be very clear at the outset in your first paragraph of your motion. What did it, if you're asking to supplement the record, say appellant requests that the court direct the lower tribunal to supplement the record. Be very clear in your wherefore clause at the very end of your motion. And be very clear with the title of your motion. Anything you can do to make the court's life easier on this front, the better, and the more likely you are to get the relief you want. If you're asking for two things, be sure you say that, because if you ask to supplement the record and have your brief due 30 days after the record is supplemented, and you only call it a motion to supplement the record and you get the order and it just grants the motion to supplement the record, you may be like, hey, what about that extension, court? And so the clearer you can be about it, so that it goes to the right place, because the court, sometimes the clerk can rule on a motion that's filed, sometimes it needs to go to a particular judge or a panel of judges. You want to be clear about what it is you're seeking. The one thing the rules do tell us is if you're asking for more time, you have to represent the position of the opposing party. I would say it's probably important to get the party's position for your opposing party's position for most motions. Again, I think it makes the
Almost every motion.
Yeah. I guess there are some that it might be weird, like the post-opinion motion or the motion for attorney's fees and costs. You can usually bet that the other side will be opposing that. But yeah, I agree with you, Matt. Almost any motion. It's just going to make it easier on the clerk's office to know, oh, this is an agreed motion. Okay, it can go right to whoever it needs to go to rule on it. Or, oh, the other side's going to be filing a response. We better hold this for the 15 days for them to respond. On extensions of time, note, the rules don't talk about this. This is one of those times you want to make sure you go to the DCAs. Almost all of the DCAs have notice of agreed extension policies. So, and that's for criminal and civil cases, but every DCA treats it differently. Matt has a good rundown of this during his annual webinar. He covers kind of all the different extension notices of agreed extension times that there are out there, and they're all different. But if the other side is going to agree, all you have to do is file a notice. You don't have to file a motion that says, we agree that my initial brief isn't due till 30 days from today, October 31st, 2021. You file that, guess what? Your new deadline, October 31st, 2021. You don't have to wait for the court. As far as time limits, there are a couple for a couple of types of motions. I mentioned post-opinion motions. That's getting us a little bit ahead of where we are in our chronology, but it's good to know that they do have a deadline, 15 days usually after the opinion. Motions for appellate attorney's fees, those are due at the same time as the reply brief is due. Oral argument requests, I believe, are due 10 days after the reply brief is filed. 15 days after the reply brief is served, which should be the same day it's filed these days. But otherwise, I can't think of a whole lot of deadlines. I would just encourage you to be timely. Don't wait till after the deadline for your brief has passed to ask for an extension. Matt talked about supplementing the record. I think that's a really important thing to do if you have a key document and not only, it just wasn't, maybe it was filed with the clerk, but the clerk overlooked it when they were putting together the record on appeal. And you need to be able to refer to that. You want that in the record, in a supplemented record if it need be. But don't wait till the day your brief is due to ask that the record be supplemented with the trial transcripts. That's something hopefully you put together before the day your brief is due. If you do, I'm not saying the court will deny your motion, but it may give off the appearance that you're just seeking to delay the filing of your brief. and that you really hadn't started working on the brief till the day it was due. There is a deadline, however, for responses. Those are due within 15 days. And I know we are getting close on time. So just also want to say there is no hearing on appellate motions. So your motion needs to be self-contained. It's not like in the trial courts where you're going to call it up for, to argue your position in front of the judge. So you want to make sure that you have everything in there that the judges need to resolve your motion. So if you're doing a motion for attorney's fees and it's based on a contract provision, include that contract provision as an exhibit to your motion. Also be mindful of the fact that you can term them emergency or time-sensitive motions. Sometimes you might want to do that. The 11th Circuit actually provides a helpful rule of thumb that an emergency is something that will be moot unless a ruling is obtained within 7 days. A time sensitive is you don't need it within 7 days, but it's still required by a date certain. But never term something an emergency that's an emergency of your own making. If you waited till that last day to file something, I don't know that the court would appreciate it being called an emergency at that point. And just fair warning, we've talked about motions, but be conscientious about filing them. I mean, as far back as 1979, the DCAs were complaining about suffering from acute motion sickness from appellate attorneys and other attorneys filing too many motions in their court. They like to deal with the briefs and the OAs and maybe not so much the motions. So it's important to do it right, but always ask whether you should do it at all before you do it.
Can I add a quick thought on all that? There's nothing in the rules that discusses replies in support of a motion. And within the practice, there's this sort of ongoing question of are replies appropriate? And I'll just give my personal view. Generally, no. I think they're largely sort of frowned on. The rules don't call for it. If you file it, it's not likely to be stricken. But try to put in your motion what you think needs to be there and try to anticipate if it's opposed, what the other side might say and deal with it then, so you don't need to look bad or look questionable by trying to file a reply.
And if I can just chime in on that, the rules of appellate procedure, the committee struggled with the idea of saying something about replies for a long time, saying that you needed leave of court to file a reply. And then ultimately fell out on the side that if the committee said that, if the rules said that, that would encourage people to ask for the opportunity to reply more often. And so it was not favored by many of the judges and other court staff. But yeah, I mean, what Matt said, I think assume you're not going to get a reply is always the safest bet.
Thank you very much, Courtney and Matt. It gives me great pleasure to introduce our second presenter, presenting the Before You Brief, presenting writing your first brief, not the presentation we just heard. And that would be presented by Lindsay Lawton, who joins me now on camera. Lindsay has a long history of clerking in Florida's appellate courts. After graduating from the University of Florida's Law School in 2007, she began clerking at the First District Court of Appeal, first for Judge Joseph Lewis Jr., and later for Judge Stephanie Ray. She clerked at the First District for almost 10 years before joining Justice Lawson's office at the Supreme Court of Florida as a career staff attorney. Lindsay worked for Justice Lawson for almost 4 years before deciding to start her own practice, Lawton Law, at the end of 2020. In addition to running her own appellate practice, Lindsay works as an appellate attorney with the Brownlee Law Firm in an of counsel role. And we're very grateful to have her here with us today. Lindsay, take it away.
Thank you, Bailey. And I'm happy to be here today with all of you. Thank you for coming. I have a PowerPoint presentation for you today. So I'm going to go ahead and get that started and share my screen. Okay, just one moment while I pull up my presenter view on my other screen. There we go. Okay, so in this presentation, I'm going to hit the highlights of what you need to know to write your first appellate brief. It's only a 30-minute presentation, so of course, all I can do is the highlights. You may have received an outline ahead of this presentation. That outline goes into more detail. If you didn't receive it, then you can download it through, I've been told you can download it through the chat feature on this during this Zoom presentation. And then, of course, even more detail beyond my outline will be in the sources I'm going to be pointing you to throughout the presentation. The scariest moment is always before you start. After that, things can only get better. That is a quote from Stephen King, probably not about legal writing, but about all writing, and I think quite applicable to writing a brief. The main thing is just to start and then go through the process. And as you'll see throughout this, the process isn't pretty, but hopefully if you go through the process and you don't take shortcuts, then you'll end up with a beautiful brief in the end. I'm going to give you a detailed step-by-step plan, and I recommend that you use it for your first brief. And as you become more experienced, you may adjust it according to what you find works best for you. If you are already quite experienced, then you may already be intuitively doing some of these things, and I hope the presentation will be a good review for you and maybe will encourage you to think about what works and help you refine your process. So like any good piece of legal writing, my presentation today has a roadmap to help keep you focused and keep me on track. So I have, the first two steps are going to be pretty quick. General setup and general writing preparation. These are steps that I would consider part of writing your first appellate brief, but they are steps you can do before you ever have your first appellate writing assignment. They're background preparation. The third section of my presentation is going to be on writing the initial brief, and this will be the longest section where we go into detail about case-specific preparation and the writing process. Section 4 is on the answer brief, similar to section 3, but quicker because there's a lot of overlap in what you might do. And then, of course, the last part is revising, editing, and finalizing, very important. So for general setup, I find it helpful to, before you ever have an appellate writing assignment or appellate brief writing assignment, to go ahead and create or obtain a blank template where you have a document that contains all the sections you're going to need in your eventual appellate brief and is already set up to create automatically a table of contents for you. You'll see here I've listed the rules that you can go to learn exactly what sections are required to be in your briefs. And I've also noted a helpful YouTube video where you can learn how to create a table of contents. It's quite likely you may have someone in your life or in your office who can create that table of contents for you and the table of authorities for you, but I always find it helpful to at least know how to do it myself, and so I can understand the document that I'm working within. And if you don't want to create your own template, if you want to email me after this presentation, I can share mine that I use when I start a new brief. It's just a blank one, so you don't have to go through and delete all the sections from a prior brief. And then, of course, as you're setting up your template, make sure you have it in the right fonts. As you probably know, there were recent rule changes in Florida, so now your brief needs to be in either Arial or Bookman Old Style, and it has to be size 14 as it previously was as well. And make sure you've got it double spaced where it needs to be double spaced, and single spaced where you might be allowed to single space it and want to do that. And all the details about that you can find in rules 9.045 and 9.210. I put here the word limits. Of course, that's not part of your template, but it's just a good idea to have in mind the maximum length that your brief can be. Not that I recommend shooting for that, but just know what it is. And then, of course, your general writing preparation that you can begin today before you ever have an appellate writing assignment is to find excellent books on legal writing. So I've listed here my two favorites, which are Brian Garner's book called The Winning Brief and Thinking Like a Writer by Stephen Armstrong and Timothy Terrell, and recently joined them, Jared Reich. When I first made the transition from being a Supreme Court staff attorney to an appellate advocate, I called around to some different appellate advocates that I knew to get their ideas on, what helped them in their legal writing. And the book that kept being recommended to me that I had not read before was Garner's The Winning Brief. In fact, one of the people who recommended that was Courtney, who you just heard from. And it was an excellent recommendation. This book is organized into tips. There are 100 of them. I think Garner recommends in the book itself that you just start reading a tip a day. And I agree with that. And it's been very helpful to me. And if you don't have time to read all 100 tips before your first brief, I've identified the tips that I think are the most helpful here. And one of them, tip number 2, is about what's called the flowers method. At the beginning of this tip, Brian Garner explains something about the writing process. He says, any writer must do 4 things in writing: have ideas, arrange them, express them, and critique the expression of them. And I think that does sum it up. And then he tells you a process you can use to do this, which was developed by Dr. Betty Flowers, who was an English professor. And this process involves basically assuming different characters throughout your writing process. So the first character is the madman, where you are just generating ideas and you're brainstorming. You're not discarding any ideas. Second is the architect, where you're starting to focus in on what you're going to present and develop the structure for your argument or your document. And then the carpenter is someone who comes in, and your character that you're assuming, and fills in all the details. And then the judge finally comes in and does the editing, you know, critiques your word choice, changes your word choice, does the proofreading. And if you're like me, you're probably tempted to be the judge the whole time. I think most attorneys are, but if possible, it is helpful to try to suppress that and save it for the end. And although I have depicted it here in a linear fashion, one thing to keep in mind that Garner explains in his book is you're going to sometimes go back and forth between the different characters. But it's just a kind of a good idea to know which one you're intentionally assuming at each stage of the process. And I spent a lot of time on that, so I won't go into great detail about the next things, but do take a look at tip number 6 with the ideal argument format and Brian Garner's ideas about issue formulation. You may not, you know, write an issue statement in a Florida brief. We don't have a section for, you know, issue statements. Usually your argument headings accomplish that for you. But the way that Garner recommends formulating issue statements, I think, is a great way for you to at least think through the logic of your arguments and get your creative juices flowing. Thinking like a writer helps you learn how to write a coherent argument, provide the necessary context for your reader as they move through your document, and is great for learning how to edit your work and others. And then quickly, another great thing to do as you're preparing is start studying other people's writing, especially other attorneys in Florida who are respected and write great briefs. I've listed some sources where you can find briefs. And then I always like to keep some of my best writing handy. Sometimes you might lose some confidence as you're working through a project or experience writer's block. Well, I think it's helpful to have something that you wrote in the past that you know is great, to go back and read it and remind yourself that you can do it. Okay, now we're getting into step 3, which is really the meat of the presentation here. As you remember from a minute ago, the first stage of the writing process that Brian Garner and Betty Flowers recommend is called the madman stage. And I would say that this describes the initial stage of your review of the case, where you're just starting to learn what the case is about. This is where you're taking notes on the record and on research that you do. And those notes are just, can be anything that you observe about the case, things that you want to remember about the facts, and potential issue ideas. And so first thing, just get to know the case, get an overview. In a civil case, read the order on appeal and any motion for rehearing that may have been filed. In a criminal case, read the verdict and the judgment and sentence. Talk to the trial attorney to help you get to know the case. Trial attorneys typically will have an idea of what they think the most important issues are. You shouldn't limit yourself to those issues necessarily, because you're going to take a holistic view of the record and try to identify the best appellate issues, but it is a great starting point. And take a quick inventory of the filings. As Matt was mentioning, you may not have the record yet, but you can often access the online docket. And so you can just sort of go through the docket and just see how long you can expect the record to be and take notes of what seem to be the most important documents. And now we're continuing to build your framework for digesting the record to understand what the key documents are and where the most highly contested issues might be. So now that you've got this really broad overview of the case, now focus in and start looking at some of these key documents. Read the complaint in a civil case, the charging document in a criminal case, read the answer and affirmative defenses in a civil case, read any motions directly leading to the order on appeal. So for example, if you're appealing a final summary judgment, you should, close to the beginning of your review of the record, read that motion for summary judgment and the response to it. Read any motions resolved adversely to your client and the closing arguments if there was a trial. I have listed here too, again, go ahead and read the order on appeal and the motion for rehearing again. Those documents you really need to be very familiar with. So it's a good idea to read those periodically throughout your review. And if by this point, you might be noticing that one of the main controversies in the case deals with a statute or a key case. And if that's the situation, read that statute or the key case next before you really get into all the details of the record, because reading that statute or that case will help you understand the significance of a lot of the facts in the record as you get to them, and may help you follow the attorney's argument. And so now you're ready to, now that you've got a really great overview of the case and a kind of a structure for understanding the case, now you're ready to go back to the beginning of the record and settle in. And I say here, touch every document. And what I mean, of course, is touch every document with your eyes, since you're probably working on a computer. And as you touch those documents, decide, do I need to skim this document? Do I need to really pour over this document? And go with that decision and take notes on the substance of the document, the key witness testimony, if applicable, and the cases and statutes that are being discussed and are important. At this point, you're probably ready to do some preliminary research. And by that, I mean, go ahead and read the cases and the statutes that you jotted down from your review of the record. Read, if it's an unfamiliar area of the law, read secondary sources and gather more cases that are cited in those sources, gather cases that are cited in the cases cited in the record. And at this point, you're just really saturating your mind with the law that is made relevant by the record. And then I've got a separate bullet point here now, after you've done that preliminary research, to start brainstorming. Now, of course, you've really been brainstorming the whole time, but I think it's helpful at this point to actually just open up a fresh Word document or get out a fresh sheet of paper and start just jotting down the issues, the legal issues that seem to be rising to the top. And at this point, you might start playing with creating an order for the issues. You might see if the issues form a kind of a story, or if there's some kind of general theme. It's really great when all of your issues can relate to each other, but of course, sometimes you do have distinct issues. But at this point, you're still just letting your ideas come out into your notes, and you're not discarding anything. You may also at this point want to play with writing out issue statements. And once you've exhausted that, now you should take a break. You can take a break. Let your ideas simmer. Go for a walk. Maybe take the night off if you can. If you must, as depicted in the bottom right corner, you can actually just switch to a different work assignment. But ideally, you'll have some downtime where you can let your ideas simmer, as they say, and maybe let your brain form connections. Once you've taken a break, you should go ahead and choose your best issues. I have here aim for 3. That's some kind of universal advice that you'll hear from judges and appellate attorneys, and something Brian Garner says in the winning brief. 3 is a good number to aim for. Sometimes you may have more, sometimes you may have fewer, but an appellate brief is not a great time to just throw the spaghetti on the wall and see what sticks. It's a great time to focus on a small number of issues so that you have the time and page length to develop those issues into something persuasive. And then, so at this point, what you're doing now is you're really putting on the architect hat from the Flowers approach that Garner advocates. And but remember, Garner recognizes that you're going to be going back and forth probably between the madman and the architect. At this point, you may not feel like you have all of your ideas fully developed, and that's okay. But you can at this point and should probably start trying to think about the structure of your document. But as Courtney mentioned earlier, each court that you'll be writing to has its own preferences, often published on their website. And so I have here, before you write anything in your brief, in that template that you've created, remember you are writing to a specific court, and so it's a great idea to go ahead and check the preferences of that court just to see if you need to adjust anything about your personal style or approach. And now you're ready to decide what order you're going to tackle your brief in. And I have approached different briefs or different writing assignments when I was working at the courts in different ways. Sometimes I find it helpful to start writing the facts out first. Sometimes it's helpful to write the argument out first, because that can really tell you what facts are important. But what you need to do is just start somewhere. It doesn't really matter where you start. And remember that whatever section you decide to do first is likely to be the most heavily revised in the end. So on the prior slide, you might have noticed, I suggested that you start with the facts first, at least, for your first brief. That's because that's probably what I do the most often. And I also suggested that you might consider including an introduction. I do need to say one caveat here. If you look at Rule 9.210, you'll see that introduction is not an authorized section of the brief. So you might want to proceed with caution. Introductions can be useful. In fact, in the Second District Court's practice preferences, they mention introductions, so they don't outlaw them. They allow them, but they expect them to be short and not argumentative. And the only reason that I like to write an introduction, and the only reason that I do feel compelled to do it, is because I think it's helpful to put in that section what issues you're going to be arguing in a non-argumentative fashion. And that to me doesn't seem to belong in the statement of the case in fact. But if you put those issues up front, what you're going to be arguing, then it helps the reader understand the relevance of your facts as they're moving through the facts section. So something to consider. I've noted an article there that discusses the pros and cons and how some judges feel about it. So next, you may want to draft your facts section. And, if you don't have a separate introduction, then put all that information that you would put in an introduction, like the nature of the case, the order on appeal, the ruling that you're challenging, up front in that facts section. Identify who the parties are, just to orient the reader to what the case is about. Because remember, as you're beginning your facts section, that your reader doesn't know anything about the case yet. And so you have to approach it from that perspective. Sometimes it's hard to remember that if you've been very immersed in the case. You might forget that you really need to start at the beginning. And when you're drafting the facts section, you might play the architect here and outline your facts section. I tend to just write this one out freely, at least on the first draft. And that's because the order to me is pretty well established by the record and the chronology of the case. I go with my broad structure is following the procedural chronology of the case. And then when I need to discuss the evidence that was presented in different phases, I fill that in that portion of the brief that's dedicated to that phase. And there's more detail about this on the slide here and in the outline. One thing I will mention and emphasize is omit dates in the facts section unless those dates are very relevant. And you'll hear that probably in every legal writing seminar you attend, and for good reason. Readers of legal writing, including yourself, tend to focus on dates. If somebody says a date, you think it's important and you try to remember it. Well, if it ends up not being important, then that can be pretty distracting. So keep that in mind and include a record citation after every sentence. That keeps you honest, and it's helpful for the appellate courts when they're reviewing your briefs and fact checking you. Okay, next, maybe you're ready to move on to drafting the argument section. And once you get to this point, you're going to be deeply focusing again on the legal points, issue by issue. You're probably going to do some deeper research, you should. And so you're basically going to go through another like madman architect process to refer back to that Flowers approach. So you'll start by deepening your research and generating ideas for how to present the issues and building the structure of the issues. I recommend using the IRAC structure that you learned in law school and hopefully have been using throughout your legal career. It ain't broke, don't fix it. The issue part of this formula serves as your introduction. You want to give the court the issue, state the conclusion it should reach, and here probably put a roadmap for the entire structure of your legal argument that's going to follow. And the more complex your argument is, the more detailed your roadmap should be as well. Here I noted Brian Garner's advice on how to address counter arguments. You should try to do that. And the way that fits in with IRAC is basically you do your general IRAC argument, presenting your main point, and then you would address counter arguments. If you're writing an initial brief, then basically you would want to address any obvious counter arguments or any counter arguments that you've already seen in the record. And then of course, bring it back to another conclusion that shows why the issue should be resolved in your favor. And so once you have that, you're ready to move on to have that outline. You're ready to move on to putting on your carpenter hat. And so you should fill out your entire outline of an issue slash of an argument. And try to do that in one setting is something that Garner recommends, and I think is really helpful for writing something that has good flow. And you make your necessary adjustments as you go while you're writing out that entire argument in one sitting. And then after that process, supplement your research if you found that there were any gaps in your logic or your knowledge. Okay, after you have a good first draft of each of your 3 issues, for example, read over your entire argument section again. And then I recommend drafting a global introduction for your argument section. And in that global introduction, you'll be listing out what issues you're going to argue, how the court should rule. And you might be thinking that sounds pretty redundant because I'm having little intros in each argument. And I know I'm going to have to write a summary of the argument. And it's true, it might be. But what I recommend is getting it on paper. And then once you're ready in the review process, if it seems redundant, you can make adjustments to ensure that it's not so redundant. But especially if you have a complex document, the more kind of organizational paragraphs to help your reader see where you're going you can have, often the better. After you have a solid first draft of your introduction to your argument section and then all of your individual issues slash arguments, you're ready to draft the summary of the argument. At least that's how I like to do it. I save it for last because that's when the issues are really crystallized in my mind and I can present a very concise and persuasive summary. And then of course here I noted, and of course draft your conclusion. I think the rules in Florida contemplate that your conclusion is not super detailed. So you're basically just telling the court what relief you want. Okay, so that is in a nutshell how I would recommend that you approach your initial brief. And now we're ready to look at how to do an answer brief. Again, I'm not going to go into as much detail here. There is a lot of overlap in approaching answer briefs with a few key distinctions. So, your first step I would recommend is reading the initial brief and then after that, go ahead and review the record and do that in much the same way that you do for the initial brief, but with focus directed by the issues that are raised in the initial brief. When you're trying to get your big picture or overview of the case and structure for understanding all the details, then you might start with the key documents that the initial brief makes relevant. As you're going through, pay attention to whether each issue was preserved. Also consider whether you have any argument to make that the court doesn't have jurisdiction. Those are always great if you can make those arguments in an answer brief. Another thing to remember as you're looking through the record is the tipsy coachman doctrine. When you're writing an answer brief, you love the tipsy coachman doctrine, and that doctrine is recognized by all the appellate courts in Florida, and it is that I'm sorry, how do I articulate this? The appellate court should affirm the trial court's judgment if the trial court reached the right result for any reason that's supported by the record. And so that's always a good thing to throw in. Sometimes the initial brief might actually show an error in the trial court's reasoning, but you might be able to point to something else in the record that shows why the trial court reached the right answer anyway. Always a good thing to be able to argue in your answer brief. So after you've done that record review, then I would recommend rereading the initial brief, taking notes on facts that you might want to clarify or supplement, and on cases that you might need to discuss in your answer. And then of course, do your research similar to how you would have done it for the initial brief, write your outlines for your responses. One thing to keep in mind that probably all judges and court staff prefer is follow, if at all possible, the order of the issues that was established in the initial brief. Don't try to think you can take control of the appeal by reordering the issues. That really just makes reviewing more difficult for the court. So once you've established your order and you've made your outlines, go ahead and fill in those outlines, again, in one sitting if you can. And another thing to think about as you're writing your answer brief is that it might not always be necessary to draft a fact section. Rule 9.210 says that the answer brief may omit a statement of the case and facts if the initial brief statement of the case and facts is satisfactory. Now, you usually are going to want to draft a fact section, but not doing so is a worthy consideration. I have, as a law clerk, I sometimes saw answer briefs that just duplicated basically the fact section of the initial brief, and as a reader there, I wondered why. It felt like a waste of time to read exactly the same facts. But a good idea is, focus, if you probably will find some areas where you disagree with the initial brief's presentation of the facts, or you feel like something needs to be supplemented. And so that should be your focus when you're thinking about how to draft your fact section. And then of course, you'll need to add your argument summary and your conclusion. And that covers answer briefs. And you'll notice I'm not mentioning reply briefs because I assumed in writing this outline and developing this presentation that your first appellate brief would likely be an initial brief or an answer brief. And now I'm ready to move on to the last section of my presentation, which is on revising, finalizing, and editing. I have up here one of my favorite quotes about writing that is, "There's no such thing as good writing, only good rewriting." And I think there's all kinds of iterations of this quote said by different people, but it's very true. So again, if possible, once you've gotten your first draft of your initial brief or your answer brief based on the process that I suggested in steps 3 and 4, let some time pass so that you can review your brief with fresh eyes. I would say your first review of your brief should be basically just, if possible, again, suppress that the judge part of you that wants to proofread and critique all of your word choices. And at this point, I guess this is still the judge, but it's sort of looking at the bigger picture. Read your brief and see, does it sound logical? Are there gaps in the logic? Have you addressed any obvious counter arguments? And if you find those gaps, then go ahead and fill those in. And then you're going to want to read your brief again. You'll see I'm recommending that you read your brief as many times as you're able. So after that first review, you might review it again and this time focus on proofreading, refining the language. And then ideally you will always have someone else who can read it too. Have that person read your brief without knowing anything about the case, and then incorporate the feedback that you get. And it's a really good idea, if you can, to line up that reader in advance. Maybe ask that person to commit to reading your brief a week before it's due. And that'll give you a healthy built-in review period and maybe a little bit of accountability for trying to get that brief close to final form early. So after you've done that, make sure you check all of your citations, including your record citations and your citations of authority for accuracy. At this point, you're probably ready to fill in some of the details that the table of contents, table of authorities, and so forth. These sections I recommend saving to last so you don't have to keep going back and redoing the page numbering. And then once you've done that, check your headings and the overall appearance of your brief. If you see at this point any headings that are at the bottom of the page with nothing below them, that's when you should go ahead and move that down to the next page. I try to save that till the very end because things always get bumped around. If you can, proofread again. And then check your word count to make sure you're within the rules and the accuracy of your tables of contents and authorities. And then here's the big one, check for confidential information. This is another thing that I would recommend you start becoming familiar with before you ever have your first assignment. I've listed here the rules of judicial administration 2.420, 2.425, and rules of appellate procedure 9.045 and 9.050 that list what's considered confidential information that might be contained in a brief and what you should do about it if your brief has that confidential information. Basically, you should file a motion with the appellate court to determine the confidentiality of the information. But it's really good to know about that in advance, because once you've exhausted yourself with all the heavy lifting of writing a brief, you don't want to be surprised at the last minute when you go to file and you see this big red disclaimer, this big red warning that you were responsible for making sure you've done the right thing with confidential information. You don't want to be surprised by that. So after you've done that, sign the brief, delete the metadata if you want to. And in the outline that's been distributed or that you might be able to access later, I've given you a step-by-step guide for how to delete metadata. And metadata includes things like, how Microsoft Word will tell you who the original author of a document was, or if you have any tracked changes and comments left in, you can make sure that you clean that up before you submit it to the court. And then once you've done that, save it as a PDF and file it through the Florida Court's e-filing portal. And congratulations, you've written your first brief. Thank you for listening. And if you want that blank template, it's very basic, but you could find it useful. If you want that, feel free to contact me at lindsay@lawtonappeals.com, or if you just want to chat, I would love to hear from you. Thank you.
Thank you, Lindsay.
You're welcome.
And now we'll move on to our first full panel discussion of the day on a subject where we find many navigational shoals in appellate practice, and that, of course, is oral argument. And I'm the moderator for this panel, and it gives me great pleasure and a great honor to be joined by Secretary Simone Marstiller, Judge Rachel Nordby, and Jonathan Williams. So quick, brief introductions about them. Secretary Simone Marstiller was born in Monrovia, Liberia. She grew up in St. Petersburg, Florida. She earned her bachelor's in business administration from Stetson and her Juris Doctor cum laude from Stetson University College of Law. Our time constraints do not permit me to recite the full details of her distinguished career in public service, but amongst other things, Secretary Marstiller has served as the Assistant General Counsel to Governor Bush, the Chief Appellate Counsel for the Agency for Healthcare Administration, General Counsel for the Department of Management Services. For 6 years, she served as a judge on the First District Court of Appeal. And after serving for 2 years as the Secretary of the Department of Juvenile Justice, she was appointed as the Secretary for the Agency for Healthcare Administration in February of 2021. Welcome, Secretary Marstiller.
Thank you so much.
And Judge Rachel Nordby was appointed to the First District Court of Appeal by Governor DeSantis in 2019, in October of 2019, and she took office that same month. Before her appointment to the bench, she was a partner in the Tallahassee office of Schutz & Bowen, and she served as the vice chair of the firm's appellate practice group. Before joining Schutz & Bowen, she served as the Senior Deputy Solicitor General and Florida Attorney General Pam Bondi. She did not serve as Attorney General Pam Bondi. Before joining the Office of the Attorney General, she clerked for Judge Bradford L. Thomas of the First District Court of Appeal. She graduated in 2008 from my alma mater, the Florida State University College of Law, where she served as the editor-in-chief of the Florida State University Law Review and interned in the chambers of Florida Supreme Court Justice Harry Lee Anstead. Her undergraduate degree in classical studies, summa cum laude, from the University of Florida. Welcome, George Nordby.
Thank you.
And Jonathan Williams maintains a diverse litigation practice through his Tallahassee-based firm, Jonathan L. Williams, PA. He was a Deputy Solicitor General in the Florida Office of the Attorney General, where he represented the state and its officials in high-profile state and federal appeals. Since returning to private practice, he has continued to have an active appellate practice before Florida's state and federal appellate courts, including the U.S. Supreme Court. Mr. Williams has been recognized by super lawyers as a rising star and as a lawyer on the rise by the Daily Business Review. He began his career as a law clerk for Judges Lee H. Rosenthal of the U.S. District Court for the Southern District of Texas and Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit, after which he was associated with Williams & Connolly LLP in Washington, D.C. and Lash & Goldberg LLP in Miami. He's a graduate of Princeton University and Duke University School of Law. Welcome, Jonathan.
Thank you.
And thank you all for joining me here today. And so the simplest place to start, at least deceptively simplest, is probably what is oral argument and what is it not, perhaps more importantly?
Well, I'll get us started with just some context. So statistically, only about 4 to 5% of total cases at the first DCA get set for oral argument. So an overwhelming majority of cases that are filed here are disposed of based just on the written filings. So the oral argument cases are a small percentage of our docket, but they add value for the court in that they allow us to break beyond the limits or the barriers of the briefs and actually engage with the advocates and flesh out issues and arguments and really go beyond the answer, the reply brief. It's intended to be a formal discussion between advocates and a panel of judges who are going to decide the case. And really, it's an opportunity for both sides to listen to each other, for an advocate to listen to our questions and understand what we're focused on and answer them as persuasively as possible in order to convince us to rule in favor of their client.
Judge Nordby, I think you hit it on the head on that. Just, from my perspective, for the time that I was on the bench, it really is it's full on advocacy, right? And if the court, at least the first DCA, because if I'm not mistaken, some of the district courts of appeal in Florida, if you ask for OA, you get it. Some courts are different. So the judges look at the cases and determine whether or not they feel they need oral argument or would like OA to help clarify some things, right? But that really is it is the court wants to clarify some things. This is your opportunity to really advocate and to help clear up what might be some either misunderstandings or I wouldn't say weaknesses in your argument, but you know what I mean? Yeah, weaknesses in your argument. And the judges will help you get there. Look at it as an opportunity not to argue. It's not like being in a trial court sometimes where it can be ratcheted up and it can be emotional. It's very much an academic conversation between the advocates and the court. So it really is a time to shine.
As the only one of us who hasn't been on the bench, my thoughts are purely from a practitioner perspective. And since I also do a fair amount of work in the trial courts, I think about appellate oral argument somewhat in terms of how it differs from arguments you might have in a trial court, either federal or state court. There are not a lot of rules about what you need to present to the court before you go argue in front of a circuit judge in Florida State Court. There are a lot of rules about what your written presentation needs to be before you get to oral argument in the appellate court. And so I think in a lot of ways, oral argument has a much, much smaller role in the appellate process than it does in the trial court. And so that's something you need to be thinking about. A lot of people will file motions, and particularly in state trial court, and say, I'll get to explain this when I get to the hearing. I'll get my special set, it'll be X amount of time, and I'll be able to talk through everything. If that's what you're thinking in your appellate oral argument, you're getting it completely backwards, and you're going to be in a really bad situation once you get to oral argument. You should not be counting on having oral argument, and you should not be counting on being able to make a new point at oral argument, because you can't. So we just had the presentation on writing your brief, and by far that is the most important part of the appellate process. And as you've heard already, by the time you hit oral argument at the appellate level, you really are answering questions that either weren't addressed in your briefs, or where you want to bring, often you'll find yourself in a position where your opponent will have made an argument and you want to bring the court back to what you've already said about that and maybe explain and amplify it a little more. So it really is an opportunity. I think of it principally as an opportunity to clarify any misunderstandings that the panel might have going into argument that might have been created during the argument itself, and to kind of focus on what the key issues are in order for your side to win the appeal.
Well, and to that end, to bring out the value of oral argument, especially given how rare it is to do in the average attorney's career particularly, but in just the total caseload of the court's context, how should you prepare in terms of what materials you should bring to an OA? What's your sort of general practice for what you bring into the room with you, and how do you use it?
I'm happy to start with that. I really think the materials you bring, especially maybe less so in your first argument, but it's a lot about having whatever you think is going to make you feel comfortable when you're up there. If you're really concerned that you're just going to forget everything when you get there and you don't have 10 documents in a binder, take those. You're not going to be able to look at them during the argument, but take them. And I think what's really important is to just have whatever sort of security blanket you need when you're there. But that said, I think there's a minimum, and you definitely want to have your briefs. It's entirely possible that you'll get a question of, is that in your brief? Where? Be able to answer that. I think if there are really key facts in the record, if you have a record intensive appeal, You might have a list of key record sites. Good for you if you can remember all of those citations, but if you can tell the court, this really important fact is located right here in the record, that's immensely valuable, particularly because courts are really good at figuring out what the law is. Where you have a real comparative advantage is you're supposed to know the record and you're supposed to be able to get that to the court easily. So I think if you have a record intensive case in particular, having a list of key record sites can be very helpful as well.
And one of the situations that, as I was talking to people about what they might like to hear from this panel, one of the things that people said just plunges them into the advocacy equivalent of cold water is how to respectfully tell the panel no, and just say, no, Your Honor, that's not the answer, or Your Honor, I disagree with that statement and here's why, and to work it in a respectful and effective way. And so is there a way that you have found, any of you in your practice, to be most effective at that? Is there just a habit you do, or do you just say, no, Your Honor, it's not, and plow ahead?
I mean, I think it's okay to say, Your Honor, respectfully, that isn't the case, and here's why, and then explain and redirect, right? Most judges expect that from the advocates. So long as you do it respectfully. I have seen it done, and perhaps not as respectfully as it could have been done. But so long as you do it respectfully and you tie it in to your argument, and don't feel like now you're going to be sort of dragged into a back and forth with a particular judge. That you definitely don't want to do, because you're not arguing with the court. But it's okay to say, well, respectfully, Your Honor, I disagree, and if this is why, if you look at the record, blah, 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 or, well, if you look at the case of blah, 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 it holds such and such. You can do it. There's a way to do it. The judges expect it and they understand, but don't get defensive and don't be argumentative. Those would be my two pieces of advice.
And to build on that, Secretary Marsteller, you hit it on the head. Don't be defensive. Don't be argumentative. At all times, be respectful and courteous, and back up your answer, explain why. Mm-hmm. And one thing I would throw out there, before your first oral argument, I would strongly recommend that you go watch an oral argument either in person or live streamed, or every DCA has arguments, archived video recordings of them. And it will surprise you how much you will pick up from watching other attorneys argue before different panels, and you'll see what's effective and what's not effective. And you'll kind of, have some experience seeing it unfold before you walk in and give your first argument. So I'd highly recommend that.
Great advice.
And I actually think it's really critical that if a judge is making a point or voicing an understanding of your argument, or saying anything that you just think is incorrect, particularly in a way that might be important for your case, to be very clear that that's what your position is. I mean, I think this goes back to the point that what you're really trying to do is make the issues and your argument clear for the court, so that they understand what your argument is and then can act based on that. So I think it's really critical if you're getting something from the court and saying, don't you agree that X is right? And the answer is no, you just say, no, I don't think it's right, and here's why. Mm-hmm. And often to think about, if the message from the court seems to be, well, it's nice that you think that, but I disagree, to also be thinking in terms of, but Your Honor, even if we accept that point, there's this other point under which we still win. So if you have an opportunity, that might be an opportunity to pivot to a different point in your argument as well. And the other thing about the no question and is also, I think it's useful in all answers to take a breath before you answer and make sure that you understood the question, because sometimes people will expect oral argument to be more combative than it is, and think that they need to disagree with more things than they're actually need to disagree with. Before you tell the court no, just take a breath, make sure you understood the question, and then proceed.
Well, and if you're not sure you've understood the question, is the best thing to do to try and answer it as best you understood it, or to begin with sort of a hedging clarification of, well, Your Honor, if I understood your question correctly, the answer is X, or is it right to ask for clarification sometimes?
I think it's perfectly okay to do either, well, if I understand your question and answer it, I think that's okay. I have asked the judge who asked the question, Your Honor, I want to make sure I understand what you're asking, and will, sort of repeat it back or paraphrase it to make sure that I'm getting it right. Because you want to answer the court's question as best as you can, and you want to answer the question that's being asked, not answer the question that you necessarily want to answer. There's a way to get there. But I think it's okay to ask for that clarification. I've done it. I've had it done, to me, and it's perfectly fine.
And from, the court's perspective, we're asking that question for a reason. And so we really want a responsive answer. So we have an interest in making sure that you understand the question. So I'm happy when advocates ask for clarification if they're unsure, because that means they're listening and they want to be responsive to the questions we're asking.
I will say that having gone through the cringe-inducing exercise of watching my own arguments, that I've found times where I really wished I had asked the clarifying question, particularly because, as I was saying before, sometimes you can get what's a friendly question, not realize it because you didn't ask for the clarification, and then have missed an opportunity to answer what was a very friendly question in a way that would be very helpful. So I think clarifying can, when done respectfully, can be very helpful.
Are you watching your own arguments from the standpoint of trying to do self-criticism, or to try and prepare things for perhaps a further appeal or for a different case? What is it, a regular practice of yours?
It is a regular practice of mine. Of course, it's easier in state court. And it's principally for self-criticism. It's also, I tend to think they went worse than they did when I'm done. So it's also a little bit of a pick-me-up. But I think it's a really good opportunity to figure out what you're doing well and not doing, in addition to, of course, watching other advocates. I think it's useful to watch advocates who don't do well and advocates who do very well as well.
Mm-hmm. Well, and on a, I guess, related point to that is the necessity of not just reading your panel, but recognizing when a friendly question has been asked and then using it effectively. And because courts do ask questions with the expectation that you will answer them and provide useful information through that. And friendly questions are a way that courts will sometimes do that. But if you don't respond to it well, it's not always helpful to the court. And so is there a good way of recognizing a friendly question, and then once you recognize it, to be able to use it effectively, or is it just something you build with experience?
I think from my perspective, I mean, all of this, with more time and experience, you become a much better advocate, and you become, better at recognizing those things. I liked the advice that Jonathan gave just now about taking a breath and taking a moment before you answer a question that is posed, so that you know for sure what it is that you're being asked. I think that if you can do that as an advocate throughout your argument, I mean, I've done it as an advocate. You're up there, you've got, 15 or 20 minutes, you are in the thick of it. You're not necessarily listening as well as you should, right? You're thinking ahead to, you hear the first few sentences and you think, I can name that tune. And you're thinking ahead to what your response is going to be before the judge has even finished his or her question. And it's really important to listen closely to what is being asked, no question about it. But also, just in the course of normal human conversation and discourse, your judge, the judge is asking you a good, friendly softball question, I have not, it's would not be unusual for the judge to, you know, do a slight head nod or to smile at you a little. It happens, folks. You need that, and that's part of reading the panel and connecting with the judges on the bench during the advocacy and the argument. There are cues, there are physical cues, there are sound cues. It's about the tone of voice and the way the question is answered, the body language, all of that plays in. And if you get it right, man, you can hit a home run.
Yeah, and that's so key, paying attention to the panel of judges in front of you to the extent you can. You don't want to just sit there or stand there at the lectern and read your OA outline. You want to be engaging with the panel, making eye contact, trying to read that room. And, you know, you can tell when you give an answer and it's maybe not as responsive as a judge wants, and you just need to do your best to engage. If you get a question and you think it's friendly and it's kind of honing in on a part of the record or a certain controlling principle or authoritative case law, you know, back it up. Say, you know, yes, Your Honor, you know, in the record at pages X through Z, you know, we preserve this issue. Just do your best to kind of pick up on it and pivot to kind of reinforcing it. But yes, that's supported by the record. Yes, the case law supports that. And here's the case. And
I will say, I wouldn't overthink it though. I had an argument a couple years ago where I was in a colloquy with a member of the panel, and I still don't know if the questions were friendly or not. I mean, the opinion's out. I was puzzled at the time. I was puzzled later when I rewatched it. I was puzzled when I talked to people. I mean, you know, the answer is going to be the answer, right? So I think, you know, just as much as recognizing the friendly question is, you know, be measured and in your response, and don't react to even the most hostile questions like they're hostile, right? Because every question is an opportunity to convey your point. And so just keep that in mind, that, you know, even with the tough questions, even with the hostile questions, that's an opportunity to clarify what your argument is, an opportunity to think, oh, well, maybe that's not going well, I should pivot to this other argument. So they're all, you know, they're all useful questions, even if they seem tough.
And I guess on more of the reading the panel side of it too, when you get an order for oral argument, it tells you who your panel is going to be, unless the panel changes. And of course, everybody's instinct at that point is to start trying to make predictions about, well, what are they going to ask? Or is it going to be a hot panel? Is it going to be a cold panel? Are they going to be receptive to my arguments? Are they not going to be receptive to my arguments? And, you know, we've all four of us clerked at various levels of various court systems. And of course, one of us is presently and the other previously has sat on the bench. And I'm interested in whether, based on your sort of collective experience, those predictions have much value, or whether they're more an intellectual exercise that can be used to help you prepare for what you think the problem in your argument is, irrespective of what the panel may think. And I asked that question in obviously a pretty loaded way, makes it clear where I come down on that, but I'm very interested in hearing what you all think.
We all do it. I did it, right? I think it is important as you are doing your background work, for example, going online and watching prior oral arguments with, you know, if not that same panel, one or two of the judges who are going to be on your panel, to see how those judges interact with the advocates. It doesn't hurt to, you know, do a little more research to see some opinions that, you know, any of the panel members have recently authored, so that you get a sense of that person's perspective, you know, that kind of thing. I never did any predicting, but I always tried to know as much as I could about who my panel members were and what I might expect, right, from each of them when I got to the podium to make my argument. But you know, you're always surprised. Sometimes the judge that you think is going to be in your corner asks the toughest questions, the most challenging questions, which doesn't mean that he or she is not in your corner. It simply means on that, you know, on that given day, those were the questions that that judge had, and you answer them as best you can. The other thing that you really can't and shouldn't do is walk away from your oral argument trying to guess which way the court is going to go. You know, I mean, I wouldn't say you never know. You have a good feeling, but we've all been there. The three of us on this panel have all, I'm sure, gotten a decision from an appellate court that when we looked at it, we're like, is that the same case that I was in? It's that, it happens. But in the way of, you know, in the interest of preparing as much as you can, yes, learn as much as you can about your judges, watch them at oral argument. I think that's the best preparation. Predictions, I leave that to the bookmakers in Vegas.
I think looking at your panel in advance and seeing what they've written is really an essential part of preparation. You only at the DCA level, you got to get 2, right? And you might have already lost one because that judge wrote on your issue a week ago, and you know, you can distinguish that case, but maybe not that great. And so you need to think about that. You might find that it doesn't look like any of the panel members have dealt with an issue like this before, and so you can know that maybe you need to start a little more basic than you thought you did. Because keep in mind that appellate courts see an immense array of issues, and unlike particularly federal district court judges who live with your case for a long time, your argument in particular is just a blip. They'll pay good attention to it, but it's a blip. It's a blip in their amount of time. It's a blip in the universe of case law. So I think you need to, part of that prep process can be, well, does this panel look like it might be more familiar or less familiar with this issue? So I think that can be very useful as well. But I also don't, you know, if you've got a panel that you think is going to be set against you, it's not like the result of that is, oh gosh, well, I guess I'm just going to lose. I mean, you still have to go in there and make the arguments you think are going to be the best arguments. So it's an essential part, but don't let it be too over determinative of your approach. There is certainly a balance there. And yes, I think the only thing you can predict with reasonable accuracy after your argument is that your client will be in disbelief as to how long you advise them that the opinion is likely to take. Because again, it's a blip in the court's overall caseload. And so I think that's the thing you can predict that will disappoint your client the most if you get it wrong, because a lot of times people want immediate answers and they think there's an argument and then there's an answer. So you know, that's something to keep in mind when you are thinking about predictions as well.
And coming out of an oral argument and talking to the client is a thing that's, you know, fraught with, at least in my particular case, nerves, not necessarily difficulty, but certainly something that is not a thing they teach you to do in law school or when you're clerking. It's something that you have to confront, though. If you do an oral argument, someone's going to want to talk to you about it afterwards. And as part of providing good customer service or good client relationships, it's important to do that well and in a thoughtful way. And so what are some of the tips you would have for doing that right and managing the client's expectations well, or doing it wrong and failing to manage the client's expectations well?
I think even before oral argument, there's a client management aspect where you explain what an oral argument is and the purpose, kind of what we've been discussing now, and, you know, how statistically very few cases get set for oral argument. Most cases are decided on the written filings and just kind of talk them through so they know what to expect. And if you have multiple issues that you've raised in your brief, prepare them to say the judges may just focus on one issue. They may want to talk about everything. The panel may have a lot of questions. The panel may not ask any questions. So just kind of giving them a preview of what to expect about the argument, that I think can help.
Yeah, I think that's right. And I guess all I would add to that is what I just said, which is that I have always found that clients are very surprised at the amount of time it can take a court to render a decision, and need to be prepared on that issue in particular. And then a lot of it is just knowing your client, right? I mean, if your client is going to expect to just have you blow away the court and have them, fawning at your brilliance, that's not going to happen, right? So I think, you need to understand where your client is and what ideas they might need to be disabused of, which is really less a question of what the process is and more a question of what your client's sophistication vis-a-vis the legal system is, and what they might think an oral argument is. And for that reason, I think what Judge Nordby said about preparing the client is very useful.
And then to sort of loop back to the beginning of getting oral argument in the first place. I mean, some people like me really enjoy doing oral arguments and are therefore more inclined to move for it than not as soon as we see an opening. And some people think people like me need professional help because we feel that way. But obviously there is a strategic component, and the ultimate goal is to do what's best for your client and will best advance their cause. And so when you think about moving for oral argument, when the question comes up, what are the things you consider when determining, whether to move? Is it, I'm an appellant, I should move for oral argument. I'm an appellee, I shouldn't move for oral argument. Does it depend on the type of the case, the issues you've raised in the case, or how necessary it's going to be to draw the lines for the court as you interpret your arguments? Or what do you consider? How do you decide that question?
Well, when I was practicing, my clients were always institutional clients, primarily state agencies. So we were normally the appellee. And so the, appellants tended to be the ones to request oral argument. But I have done, a few cases in which I did request oral argument because the issues were important, because I knew that they would need to be clarified before the court. And I wanted to be able to do that. Again, as I said earlier, I think some district courts of appeal will grant oral argument if you ask for it. I think, okay, admittedly, now it's been a while since I have filed a motion for OA, but I think you do have to do a little bit of explanation about why you're asking. And that I think is reasonable. I don't and never would have subscribed to the ask for it 100% of the time. I think it really depends on what your case is about, whether you as the lawyer who is asking for oral argument, whether you really think that oral argument is going to help the court understand the issues in a way that you would like for them to understand it. I also, as appellee, I don't believe I have ever objected to a request for oral argument. In my opinion, that's not necessarily a good look, but there may be good reasons for it. For example, if you as the appellee know that the issues that the appellant has raised on appeal were not preserved, you might want to say, I think that this, can be resolved on the briefs. But I would be careful, right, in challenging or objecting to a request for OA.
Just to kind of give the internal perspective here at the first DCA, when an OA request comes in, it's circulated to each judge on the panel. And if any one of those judges individually thinks OA would be helpful, then they can set it and grant the motion and set it for OA. So it's not where you have to get 2 judges on board to grant OA. If it's just 1 judge, then it's going to get set. Just to give you a glimpse into my thought process, I'm a pretty stringent OA grantor. I really want to reserve it for the cases where it really is necessary or would be helpful. So I tend to look for cases where there's significant issues of first impression, constitutional challenges, statutory interpretation. In the criminal context, if there's a significant criminal procedure issue, or the defendant's been sentenced to a very lengthy sentence and there's some serious issues being raised. On the civil context, if there's a large jury verdict, those are kind of the factors that I look for. And then sometimes you'll just come across a case and it's just when it's obvious, just OA would really be helpful to get us all in the same room and have that dialogue about these issues and flesh this out. So that's kind of my thought process. But every judge is different. So
I do think from a litigant perspective, one thing you do need to think about is that oral argument is a big undertaking. If you're going to make it useful to the court, you need to know the case back and forth. Ideally, you will have done a moot. And if you're charging a client by the hour, that's a lot of money. And one thing to think about is, is asking for oral argument really a good use or a good enough use of your client's resources? And in many cases, I think the answer is probably no. I mean, it's not, because sometimes a court will look at a case and think, oh, well, we do need to understand this a little better. So it's not as if you're guaranteeing that you won't, you're making it less likely, but you're not necessarily guaranteeing that you won't get an oral argument if you don't ask for it. And so you should really think about the value of an oral argument. And another wrinkle here, of course, is that in the federal courts, in the 11th Circuit expects you to say something about whether there should be oral argument in your brief, regardless whether you want it. And I think people overlook that as an opportunity for advocacy as well. I think throughout your brief, and even when you're thinking about what you're conveying to the court about oral argument, it is an opportunity to focus the court on what matters or doesn't matter about that case, particularly whether it is a very important issue that they need to pay attention to, or maybe oral argument would be useful because it's a very complicated record that can be explained and amplified in person a little better. So also do think about the reasons for oral argument against the background reality that Judge Nordby has explained, that most cases aren't going to get it. So if you want it, you do have to make the case.
And just to throw this out there, we've mostly been talking about when parties request oral arguments. Do be aware that the court can, on its own, set oral argument on anything. Either if a case is fully briefed, we can look at it and say, they haven't requested OA, but this is one we need to have argument on. We can set OAs on motions, motions for rehearing. Those have happened before, where a motion for rehearing comes in and the panel says, we didn't have OA the first go round, let's set this because the motions raised some interesting issues. So be aware that that's out there. It happens rarely, but it can happen.
And at the Supreme Court of Florida in particular, the OA determination is usually made at the time jurisdiction is accepted, and that the case is jurisdiction is granted or accepted and review is granted with oral argument or without. And so you have to take your shot in the jurisdictional briefing most of the time. And so we are coming close to the end of our time, but I have one last question I'd like to pose to you all, which is the the question that I think many sort of braver minds might approach oral argument with when they're requesting it, which is, well, what's the worst that could happen? And that more sort of sober minds might approach as, well, what's the best that can happen? And I'd like to hear what's the best that can happen on OA, or what's the worst thing that can happen on OA, and how can you then go on afterwards and continue to successfully advocate your case?
Oh, Jonathan, this is all you.
I'm not sure
Jonathan,
which
what's the
part of
worst that
that
can
question
happen?
makes it all me, but I'll move forward. So I really do think, and it's not necessarily the most fun thing that can happen, but I think the best thing that can happen is during oral argument is that you realize that there is a misunderstanding about what your argument is, or that an aspect of the case that is important has been overlooked, because that's really the biggest opportunity you have to help the court understand why your client should win, because it gives you the opportunity to say, no, that's not quite our argument. It's not foreclosed by this case because it's different from that case for this reason. And it gives you the opportunity to orient the court to what your argument actually is, and maybe to adjust your argument a little bit to make it what it needs to be. Because I really do think you don't necessarily get oral argument. It's rarely going to win the case for you. But it really does give you a chance to have the case that you want decided if there's confusion. So I really do think the best oral argument is that oral argument where you realize that you weren't quite as clear as you could have been in your brief. And so you have this opportunity to correct it. The worst thing that can happen with oral argument,
Realizing that 5 minutes
I
after
think the
you
worst
have the
thing that
oral
happened
argument.
in oral argument is, and this is why I say it's psychologically damaging to look at old arguments, is when you realize that you had that opportunity to clarify something and you just missed it. And that's going to happen. And that happens to everyone. It happens to everyone deep in their careers. And you just have to kind of forgive yourself and move on. But there are unforced errors. So, an example I think of that I will anonymize suitably is I saw an argument where somebody started out by telling the court that it was going to be the easiest case that day, and that advocate lost unanimously. So, I mean, first of all, that doesn't actually convey any useful information. And second of all, when you think about it from a client management perspective, gosh, I mean, you've really misread the court. So I don't think telling a court a question is easy is very helpful. I think telling a court a question is hard and acknowledging that your position might not be a slam dunk, but nevertheless you prevail. I think that can be very good. So it really is an opportunity that you don't frequently get. So view it as that. And I think that's the most likely way to lead to the best kinds of oral arguments.
Definitely. Well, thank you all very much for your time here on the panel today. I've certainly enjoyed it, and I hope that you all have, and that all of our viewers have as well. And now I will turn it over to Russell for our next session.
Thank you all so much.
Thank you.
Thanks.
And Bailey, thank you so much. Some great panels already, and I am thrilled to be handling our last substantive panel. We have a great group of speakers for this one as well. Let me just introduce our panel. We have Judge Timothy Osterhaus, who was appointed to the first DCA by Governor Rick Scott in May of 2013, which does not seem possible. I still remember Tim being down the hall at the Solicitor General's office where he served for such a distinguished time. But time does pass. But during his time at the Solicitor General's office as both the Solicitor General and the Deputy Solicitor General, Tim handled appeals on behalf of the state of Florida in each of the district courts of appeal, the Florida Supreme Court, and federal courts. and even before he joined the Solicitor General's office, he worked for the Florida Department of Education in private practice and as a district court law clerk, where he was lucky enough to meet his wonderful wife. You know, Tim is just a great guy, tremendous lawyer and judge, and we're happy to have him here. Joining him is another SG alumni, Oz Vasquez. We didn't get to keep him in the SG's office quite as long as we would have liked, but also has a very distinguished background. After graduating from Harvard, he clerked for the First Circuit Court of Appeals and has had a really interesting career, both in public service for major law firms, and now in a dedicated boutique firm advocating for workers' rights. Oz has similarly done cases throughout Florida's appellate courts, the United States Supreme Court. He also has performed extensive pro bono work for asylum seekers and for community groups representing low-income communities. So happy to have Oz back with us, at least over Zoom. And then our final member of the panel, we're also very fortunate to have Julie Rodriguez, who is a board-certified appellate specialist partner in the Schutz and Bowen Miami office, where she focuses her practice on appellate litigation and trial support. She also advises clients on securing stays of orders and judgments while cases are pending on appeal, having handled some cases like the tobacco case where the amount of appeal was several $100 million. That can be a quite useful skill. So thrilled to have Julie join us as well. And our topic today involves basically things to avoid in your first appeal. You're lucky enough to have an appeal of your own. You're not just maybe doing a first draft of an appeal, but perhaps you don't have the hard-won life experience of having things go wrong. And I'll do this first question to Judge Osterhaus, but then would want to have perspective from Oz and Julie as well. Judge, can you talk a little bit about sort of the most common mistakes you see from attorneys on their first appeal? I mean, is it something where you can sort of tell, gosh, this is your first appeal, but what do you tend to see maybe both on the briefing side and at the oral argument side where you just go, gosh, they won't make the same mistake next time, but they're going through it right now?
Yeah, thank you, Russell. I appreciate that for your kind introduction. Thank you very much. It's a pleasure to be on the panel with Oz and Julie also. And yeah, it's a fun topic, and I'm glad to be able to share some thoughts on it. I think that before I get to sort of what I've seen and not seen with respect to briefs and OAs, I think that I can't stress enough the importance of just background, knowing your rules. As a new lawyer coming into an appellate process, there are appellate rules. Rule 9 of the Florida Rules of Procedure details how you get into the appeals court and how things go. And you really need to know those backwards and forwards. You won't even get to the point of briefing a case, for instance, if you don't know the time for filing your notice of appeal, and you don't get that get that in. You could be out on a motion to dismiss even before you get to brief anything. So Rule 9, the rules of judicial administration also, that's in Rule 2, has some things that will also bear on your appeal. It has a practice of law section. So that's another place where you might want to know the rules, starting with probably Rule 2.5 or so. And then my court does a nice thing, and I appreciated this when I was a lawyer. They sent out a notice to attorneys and parties. It's available on our website. You could download it, and it's kind of a cheat sheet to the rules, particularly as to cases filed in our courts. And so, you know, they covers, for instance, and it's updated. It was updated last in April this year. It covers filing your notice of appeal, making sure you attach the order that you're appealing to that. It talks about docketing statements, giving the court the information surrounding your case that it needs to kind of logistically, administratively keep things on track. It covers filing motions. That will happen. You might seek an extension sometime. Well, how do you do that? You might want rehearing at the end. What is that about, and what is the time limits for that? You might want oral argument. We'll talk about that in a second. And then that too, you have to seek oral argument by motion, and you want that to be timely. So this notice to the parties gets into all that kind of stuff, certificates of service, briefs. When you get into pitfalls of filing a brief, I know that back when I was practicing, I think at least once I had a brief bounce back for some reason. I forget what it was, but you hate to get those, but usually the court is kind enough to give you a week or two to fix whatever it was. And I forget what it was in my case, some formatting issue or whatnot, but there's specific rules on these things that you want to follow. There are font rules, right? There's only 2 fonts that you can use, font size rules. There are word limitations. So your briefs can only be so long. And to the extent that you violate any of these, your brief can get bounced back. And you don't want to be in that position. You don't want to be in that position with your clients. This notice to the attorneys also covers the appendix, filing an appendix. What if you have somebody from out of state who's coming in to help on your case? Talks about that. Talks about oral argument, talks about supplemental authority. Something new comes out, how do you let the court know about that? And of course, filing fees. So anyway, I commend knowing the rules backwards and forwards to you, and I commend going on our website and downloading this notice to the attorneys and parties, which gives some tremendous background information and kind of a cheat sheet to the rules. The rules are cited throughout, so that's really helpful. Now, getting, I think, more closer to your question about briefs and OA, what are the things that we see? What are the pitfalls? I think that your underlying principles here is that you want to write you're writing to an audience. You're writing to an audience of judges, and you want to educate and inform them. Recognize who your audience is. Appellate judges are generally generalists. We all have a background. There are 15 of us here on the first DCA. We all had a different substantive background as lawyers. You may or may not get one who knows your area of law, the area of law of your case. And so expect to be able to educate us as to the law, as to the facts, of course, of your particular case, why you should win, and to to tell a story that makes sense. That's the first background principle. I think the second one is guard your integrity, guard your reputation very closely. And for briefing purposes, for argument purposes, your cites to the record. You want what you say to be solid. You want to have record cites in your statement of facts, for instance. And you want when we go there to check it out, you want us to be able to see exactly what you're talking about, and not to be there. You don't want to misquote cases. You don't want to misrepresent what a holding is about that you're trying to extend or to use to further your argument. Again, that goes straight to your credibility. If you show up here more than once, those things get remembered. You develop credibility over time, and trust is something that you want to earn and keep earning, and that can be lost rather quickly if you're too loose or too quick with something. As far as briefing, pick your issues, be crisp about it, get to the point. You probably don't have 10 great appellate issues coming out of your trial court or your administrative proceeding, or or what have you. You probably do have one or two, hopefully, maybe three or four, but you probably don't have 10, and you don't want your best argument to be buried at number 6, because your reader, or we're all humans, we're going to read argument number 6, 7, 8, 9, and 10, but you do get worn down, or it could be that you'll lose some credibility with, strenuously arguing 1, 2, and 3, which are losers, but you have this great argument number 4. Well, why is it number 4? If you're putting it number 4, then maybe the attorney doesn't really believe in it. It's sort of the background things that may be going through your judge's mind, and that doesn't serve your cause well. Again, we're gonna hit it hard, and if you deserve to win on argument 4 or argument 7, you will. But I think that you handicap yourself to the extent that you don't tee that up quickly, and make that clear. There's a fun quote. I think it was Judge Easterbrook, an opinion, 7th Circuit opinion, that said something along the lines of, judges aren't pigs hunting for truffles. We're going to do our job, but to make us have to dig and search to find your best argument, that's not going to serve your cause well. So I commend that to you. Another huge distraction that I hate to see in any case is ad hominem type things. You may think very little of the opposing party, you may think very little of opposing counsel, maybe you think very little of the trial court, but in our court, make your argument, and we don't need to hear you say bad, negative things about your opposing counsel. And now, feel free to show us what you think of them by making good arguments that soundly defeat or counteract what the other side's arguing, but keep the ad hominems to yourself. Again, that's sort of a credibility thing, or it can be a credibility thing, and certainly something that's off-putting to me, and I think to a lot of judges. Turning to oral argument, I don't want to monopolize too much time here. Let's see. Oh, one other thing on briefs. I think booking in your briefs, standard of review up front, very helpful to get that right, whether it's substantial evidence, de novo. Let us know through what lens we should be reviewing the issue. And then the backside of your brief, tell us what you want. Do you want us to reverse and remand? There are different things that you could be asking if you're the appellant, if you're the appellee. There are different things that you could be seeking. Make that clear. That's helpful to us in the briefing process. That's something that you may get to an oral argument, but not necessarily. But the brief is the place to be clear about your standard review and about what you're seeking, what remedy you're seeking. As to your appellate argument, first get your notice in on time. Hopefully it gets granted if you're seeking it and it's worthy. And first of all, show up to your oral argument. We've had some instances through the years where attorneys failed to open the email. It's been a while since I've been on the other side to know exactly how these notices or how the electronic docket is working with your inboxes and your email or whatnot. But make sure that you're opening those emails from the court, or you're checking your docket so that you know that you have OA on a particular day, because you'll want to be there, and it will be embarrassing. Again, your reputation is at stake, and half the battle often is showing up. And then I think Jonathan touched on this. I tuned in at the end of the last session, but be ready for a conversation. Be ready to answer the hard questions. Be prepared. Be prepared. Be prepared. I think something that I used to do is just brainstorm all the potential questions I think that I could get in OA. It might be 30, 40, 50 different questions, and just rehearsing in my head, playing back and forth. All right, here's where this argument may go, and hearing myself, hearing the judges, and just knowing. I think the bottom line for me is I didn't want to ever be surprised by anything that was asked. I wanted to be ready to answer anything, particularly the hardest questions that for my case that the court might ask. Know those cold. Moot courts, Jonathan talked about that, are very important, very helpful. Something I like to do at the AG's office back in the day is we had somebody who was particularly loud and I don't know, abrupt in his questioning. And that's really helpful to get somebody like that, because sometimes if you're just rehearsing things in your mind, you know, it tends to be a nice, genial conversation. But judges' questions can come in different ways, and to have somebody sort of yell their question at you, or to, you know, to be kind of snippy in asking their question is something too, that's good to be able to practice and to be able to parry and respond to, and so that you're ready. So I definitely encourage that, and to the extent that that you don't have other people to just make sure that you know, be ready to answer hard, difficult questions. I'll end with somebody a couple of weeks ago sent me a blog post about I think a wonderful trial attorney, and this is in another state before another Supreme Court, had a marvelous record at trial, but decided to argue his own appeal before the Supreme Court, and it got to the point where he was being peppered by the Supreme Court justices that he said, "Enough! I can't keep up with you on this stuff. I'm done, and I'm proud of my trial work. So whatever, you know." And basically, that was the end. He said from now on he was going to get somebody to do his appeals, and you don't want that to be where you end up. Be ready to talk about the soft spots in your case, and know that's kind of why we grant oral argument, is because we do want to ask the tough questions and hear you out about why we think you should prevail.
And Judge, just one other follow-up question before we go to the other members of the panel for their input. Would you recommend that people come and actually sort of check out the room before their first oral argument? At least in my somewhat limited experience, I mean, the first DCA, like, you know, you're very close to the court, and the Florida Supreme Court, it seems like they're a mile away. And so would you find that to be a good practice, that people sort of get used to the light system and how their voice carries before their first oral argument?
I think, yeah, I think absolutely. I think that can be really helpful. I know I did that a time or two back in the day when I was arguing cases, and that was very helpful to me. So I think absolutely. In fact, that brings up another thought along that line of OA. I was in arguing an appeal at federal court in Montgomery, and the practice was I was to go to the clerk's office, which was on a different floor, to check in before the oral argument. And somehow I missed that. I just went straight to the courtroom and was ready for them to call my case. And somebody from the clerk's office came up and said, "Hey, is the attorney for the state of Florida," or maybe they used my name, I forget, "here because you didn't check in." And so that was embarrassing, and would have preferred to avoid that kind of thing. But yeah, the preparation and reading those notices very closely is very important.
Okay. And Julie, we'll turn to you. I mean, as an experienced practitioner, what are some of the sort of common briefing argument mistakes you see from people maybe just sort of starting out in this practice?
So there can be so many, right? Looking back and you cringe, right? Because you were there at some point, one of us was there. But look, one of the things that I think when you're just starting out doing your appeals is not understanding the scope of review, right? So if it's a final appeal, all the prior rulings are fair game. But when you're looking at a non-final order, right, and you're looking at one of the rules that I think it was Courtney who mentioned earlier, 9.130, you're thinking to yourself, well, here's an order that has multiple issues, but I've got it, because it deals with, let's say, venue. So I'm just going to take it up and then argue everything that's in there. But no, you've got to parse it out. That order can only be appealed based on what's allowed by rule, right? And so I've seen along the way where folks take some liberty, and I think it's really out of not knowing that the scope of review, when depending on the type of appeal, right, non-final versus final or discretionary petition, can be very narrow. And along the same lines, think of your multi-defendant case or multi-plaintiff case, right? And one party is suddenly out, right? And you're having a hard time keeping track. But if you do the math, right, you can see this person, all the claims against that person or entity are out. Well, under our rules, you have an obligation at that point to appeal, right? even if the rest of the case is still ongoing, and things like that can trip you up, which is why it's so important. And I think everyone at this point emphasizes you've got to know those rules, right? It's a bit tedious at first because I think most of us, the way we learn the rules just is by practicing little by little, right? We got mentored and we started knowing the rules of the game. But if you're in a position of here's the appeal, you got to get it done, your first task really should be, okay, if I'm dealing with, for example, this is what I do, civil appeals, right? I've got to know those rules inside and out so that I don't, for example, turn in a brief that all of a sudden says I'm 50 pages in and I'm good, when all of a sudden we know we have word count limitations, that sort of thing. I will say this in terms of oral argument, because I heard this a couple of times, and both when I was sitting as a clerk at the court at the third, and then listening to folks argue it, you get up there and this happens often, right? You weren't the attorney at the time when the record was being developed, right? Trial attorney was handling it, or maybe you're the second appellate attorney in line. That happens too. But you own that record, and to get up there and say, that wasn't me, that horrible scenario that you just described, that's on them. No, I mean, and I'm being flip about it, and I don't mean to, but in all seriousness, it's the approach of, look, the record is what it is, you own it. I don't think there's anything wrong in pointing things out in terms of how they were developed if you're dealing with some dicier situations like a sanctions issue, right? Just to make the record clear. But really what the point of oral argument, what we've heard here through today, and it's been my experience, is if they're calling you in, especially for courts like the first DCA, right? Which unlike the third DCA grants oral argument very infrequently, they've got questions for you. So you're going to have your main points that you want to highlight, but most of the conversation is probably going to be driven by those three judges who have, despite, heavy briefing, the three briefs, or maybe a cross appeals in the mix there, right? They've got questions. So, let them lead the pack, and by all means, just don't tell them that they shouldn't be talking to you about the concerns that they have, because that has not played out well ever. More stuff to come, but I think you'll probably hit it with some other questions that you have.
Absolutely. And then Oz, what are sort of the recurring mistakes you see in your own practice from either younger attorneys or attorneys just maybe who've been on the litigation side and now have been brought in to do an appeal and aren't perhaps quite up to speed?
Sure, and most of my practice has been in federal court. I clerked in federal court, and I'm an ERISA and employee benefits specialist for 90% of what I do now. And I've seen it from that perspective. And coming from even just my own experience, I think a big issue that comes up, especially early in your career, is kind of getting that comfort, the familiarity. That's why I appreciate that question of getting to the court and kind of looking around and seeing what the courtroom looks like. I think it's helpful to get those out of your system, because what you ultimately want to answer is, what do I want the judge or judges to take away from my argument? What's the 30-second sort of elevator pitch? And if I only have the opportunity to talk to my deciding judge once, what do I want her to think about my case? So for example, I had a couple of arguments in an Alabama district court very early in my career. I think I was a year out after clerking. And I went down once. I was practicing in DC, and the argument went well. And the second time, before a different judge, I was maybe a little bit overconfident, and I didn't take the time to ask, what does this judge, what's her practice like? What is her specific, what does she like attorneys to do in front of them? And just like Judge Osterhaus said, you have to check in with a clerk in the 11th Circuit, you have to do this or that, and just different court. That kind of stuff can shake you up, and it can distract you from that core message you want to get across. And it did in that argument. I said, this court held, and she said, no. You say, this other judge held, I am the court. And that threw me off my game. That went fine, but it's those kinds of things that can trip you up. Don't be ashamed, don't be afraid to ask. Another good point that to piggyback on Judge Osterhaus on moots, he had mentioned having an aggressive questioner is helpful. And not just the questioning style, but having somebody that's skeptical of your argument and skeptical of your case, I think is helpful. we had an 11th Circuit argument. It was my fourth or fifth argument, so I was still pretty new. I was at the SG's office, and we had a case that we'd won in the district court. A similar case had been brought, and the Second Circuit had held in our favor. So we're feeling pretty confident. And the moots had gone well, and I knew it was First Amendment issues, and I felt very comfortable with them, very comfortable with the record. And there was just one judge on the panel who shall not be named. He's in my nightmares, and he just did not like our statute and was just jumped on us, jumped on me, and I answered and parried as much as I could. We ended up losing that case, unfortunately. He wrote the opinion, of course, but you have to be ready for those sorts of things to be able to think on your feet. Those kinds of things, I think, they do come up early in your practice. There's no silver bullet other than preparation, having the right moot, having the knowledge of the record back and forth, and have that familiarity, that comfort level that, as other folks have said, you develop over time.
Well, I never thought my voice was loud and abrupt, but I mean, if Tim thinks so, it is. But I never have done a ton of appellate arguments, but I've always greatly enjoyed the moot, just for the other side, and for usually being the person who would sometimes, pretend to be a hostile judge or justice and really go after the person, because it can very much be the echo chamber. So Julia, let's turn to you for the next topic. Obviously, you're in a big firm. Firm has a big appellate practice, and obviously, as people come into the firm, perhaps from clerkships or for other opportunities, what kind of advice do you give attorneys when you sort of kick them out of the nest and say, okay, you don't just write the first draft of the brief this time, this is your appeal. So what kind of tidbits do you try to give attorneys at your firm, or maybe in other positions you've held, in terms of, okay, these are the things you really need to think about now that you're the first chair attorney on an appeal?
So this goes as far back as, I think it was Matt who was covering the stays and bonds issues, right? Because only second to that is what Courtney covered, which is if you blow the deadline to appeal, then there's nothing else to talk about, right? So the first thing we're looking at is just in terms of, are we timely, so that if you're gonna get this appeal and run with it from beginning to end, it's what kind of order do we have, so that we know that we're not, for example, voluntarily complying with it and therefore mooting our own appeal, right? If we have, well, you'd be surprised, right? But that happens because you let's say you want to stop interest from accruing, and you're thinking that you're going to alleviate the situation when you're only making matters worse, because now you're voluntarily giving into the order that's adverse to you. So we look at this from a number of ways, that preliminary stage of all the things that could go wrong, right? The first being the deadline issue, but also just the nature of the order is going to govern so many things. Amongst them, even there's no deadline by which to appeal, but I mean, not to appeal, but to stay. It's the practical reality of, if I've got a money judgment that's running, if I've got a sale that's about to happen on a property, and that's my main issue, let's say on specific performance that I'm challenging, I need to go in there at the trial court level and get a stay. It's discretionary, so that's going to be the fight. And if that court denies it, then I'm going to have to go to the appellate court and try to get the stay there. All the time hustling on understanding that that's going to be something expedited. So we started talking about just the mechanics of all that, so that we're not getting to the appeal and there's this wonderful argument, but we've undermined the whole process because we didn't take care of the first few steps, right? And it can come back to haunt us. But along those lines, just procedurally, it's just because you get a favorable order for the most part doesn't mean that you shouldn't be looking at it for a potential cross appeal, right? So it's issues that if things go south, right, on appeal, and they don't go as planned because you got the bulk of what you wanted, but there's some snippets there that if you go back, you want to make sure that you preserve those, right? And that you can fight it out on remand if you have to. And, I'll say this, part of what I've told folks, and this is, you learn as you go the hard way sometimes. Sometimes you write these briefs knowing, it sounds so great on paper, right? And then you start preparing for the oral argument and you cringe. You're like, how am I going to sell this, right? Because there's a practical way of communicating these thoughts and these concepts about how you want to explain the relief that you want. And you can have something very dense, right, in a brief and not realize that, these three people have to go through this and you're really making them go to task on it, right? Make it easier, especially now with the word count versus the page limit. The brief may end up being a little longer, but I think we have the ability now to make it more readable for our judges, right? Use bullet points, whatever it is, to break up the page, the subheadings, etc. But I also ultimately give this advice, write as if you were preparing for the oral argument. So it forces you to get to that point, but it's it keeps you honest and it keeps you just from, doing those long-winded sentences that go on, or thoughts that, you haven't broken up the concept sufficiently to really get up there. And I think it was one of the last speakers here who said it. It's like, you need those snippets to get your first 30 seconds across, right? Get your audience interested. They're only human. And, some stuff is just going to be very dense to follow through. They can follow it through, obviously, but you've got to be persuasive enough, especially if you're the appellant, right? To communicate those thoughts. So in my practice, at least, there was a noticeable difference in when I go back to my writing. Before, I treated it as, okay, let's just talk this through in terms of how we would present this at OA. We may not get OA, but at least I'm not going to see the holes, a few days before I start prepping for that.
Right. And I had a similar experience on the litigation side early in my career where I had a case I thought I could win summary judgment on, and the mediator said, that's great. Maybe there's a 50-50 chance you get summary judgment. What are you going to tell a jury if you don't get summary judgment? And as a young attorney, I went, the facts of the case were not great. I had a legal argument I liked, but I had to sort of go to the next step and go, okay, then how would I sell this case? And Julie, before we move on to other members of the panel, how would you advise younger attorneys to deal with some of the uncertainty of appeals? And one example I can think of just from my own experience, you're the appellant, you show up at oral argument, appellee completely abandons the brief, raises entirely new arguments, certainly if you're not someone who is used to doing appellate arguments, that could leave you pretty flustered. So how do you sort of advise attorneys to adapt when things maybe perhaps go off course in the appellate setting?
So at oral argument, it's difficult, right? Because all you can do is compose yourself when you have those last 3 minutes of your rebuttal as an appellant, right? Because you just heard your opposing counsel get up there and say something very different from the briefs. And say something, never, as Judge Osterhaus pointed out, do an attack on the other side. But I would always frame it, or typically frame it as, look, the record doesn't show that. And let's be clear about what was presented in the briefs, right? These are new arguments that are being made here today. The court will know, because they've always, in my experience, having clerked and over the years, they're going to go in prepared with, it's either memos prepared by their clerks, they're going to have a good understanding from having read the record themselves, go back to it and then double check that, somebody raised the flag that this is not right. What you heard just now is new ground. I'm not going to go into it, but you're going to see it, right? And then you just got to stay on track because you got precious minutes up there. As it is for some courts, we've been trained 10 minutes, right? For others, it's 15. And you don't have the luxury of starting to point fingers. More often than not, I got to tell you, it's with the briefing, right? So we've talked about, and I thought it was excellent, the presentation in terms of how to unpackage and get that initial brief or answer brief prepared. The other good tool in reference to what you're asking is the reply, right? So the reply can be an extremely powerful tool to do just that, right? To pick at what has been omitted or what is new. Remember, the appellee has some leeway. One or more of our speakers today spoke about the tipsy coachman doctrine, right? So they're going to have some flexibility, but even tipsy coachman has its boundaries. So when you're getting into factual findings that weren't made below, for example, right? So you can keep the appellee in his or her lane in the reply. And I've always found it useful in terms of what didn't they say in response to the arguments, right? So that if they're spinning new tales about how to support their argument, maybe they're allowed into tipsy coachman, but here's the reality. They're not answering the issues that we raised in our initial brief, right? And that can be really bad for them because then the answer is just to be filled in by whom, right? The judges are gonna look at it and as the appellant, you will be there to fill in those answers with the reply. So it can be, I think, a really effective tool, but so long as you don't rehash your initial points, but just focus in on what is the appellee doing so that, going back to your question, how do we keep them in line and point out to the court that they've gone completely off course for what the issues are and should be.
Okay, great. And then, I'm sorry.
Sorry, Russell, just very quickly. So just to piggyback, a couple of quick things. One point that Judge Osterhaus mentioned about thinking through different questions that might come up and also familiarity with the rules. As you're getting a sense of the record back and forth, as you're preparing for argument, if you see something that doesn't make sense, that may come up, even if it's not in the briefs. For example, in the federal system, Article 3 jurisdiction, that can come up. We had a case in the DC circuit where the court themselves brought it up. And you can be prepared for those kinds of questions, and you're more likely to be prepared if you are looking at the record skeptically. The second thing, it may be somewhat controversial, but it is okay to say that you don't know. If the court or the other party brings up something that hasn't been in the briefing, I'm totally comfortable with saying, my initial take is this, may I supplement with the 20HA letter in the federal system or something else. One downside at the end of the former panel, one downside to an oral argument that can happen is you make a concession you can't take back. You say something you can't take back. You lose some credibility and you position yourself in some way you can't take back. You want to avoid that. And I think it's better to be able to supplement later on than to be in that situation.
And I agree. I think that's something that maturity teaches, that it's okay to say, look, I don't know, and let me supplement. And then Oz will have the final question to you, and then obviously would want Judge Osterhaus and Julie to weigh in. Looking back at your first appeal, what would you have done differently? I mean, like when you go back and what do you wish you would have known at the time you handled your first appeal?
Sure. Well, I opened by saying, Your Honors, this is going to be the easiest case you have all day. I'm kidding. That's something that Jonathan mentioned before.
That was a classmate actually of mine, but yeah, okay, go ahead.
I'm kidding. No, I had the good fortune of clerking and clerking with a very, very sharp judge. And we saw a lot of different things that came up. And she was also just very, she kept us honest as well. So we're always very prepared. One thing that I might have done differently in my very first set of cases was acknowledging that like we just talked about, that there are some things you can't answer, you don't know. I spent way too much time sort of in my head trying to find like the possible question that might come out, the black swan question that Judge Osterhaus was talking about. There are some left field questions that might come up. There are some questions that will never come up, and chasing those down, I think there's a tendency, a temptation to try to do everything. I think focusing on your core argument, focusing on what you want the judges to take away, focusing on your case and on your record, and not necessarily looking at every opinion that the judges on your panels have written the last 6 months, those kinds of things. I think it's helpful just to get you in the right mental space. But if you're working with a good team and you've done your preparation, then you'll be in a good spot almost just by yourself.
I love that.
Yeah, and I love that point of remembering your key themes, and to the extent that you get a question out of left field, and maybe even can practice questions out of left field, but bringing them back. You know, it's such a pleasure to watch a good advocate because they are stuck on their themes. And, you know, it seems like regardless of anything you ask them, they're going to bring you back, you know, and, you know, the good ones can do it in a way that it doesn't look like they're completely giving you the Heisman. But I completely agree that knowing your themes and sticking to your themes and filtering your lens and all your question answering back to your themes is key.
Julie, any last thoughts in terms of looking back at how you might have handled your first appeal differently?
A lot of things would have been different. No, listen, to me, because you go back and you read the stuff, forget the OAs, right? Try not to look at those again. But the briefing tends to be what carries the most weight, right? Because as we've talked about throughout the day, you're not guaranteed oral argument. And when you do get it, it's very brief. So by and large, I think our system is just geared to those briefs have to be as perfect as they possibly can be, both to educate the judges, to be persuasive, and to be transparent, right? So that someone else talked about those record sites, go back to them before you file those briefs, you know, double check them, because if somebody starts looking at those sites and it's the wrong case or whatever, not only do you start losing credibility, but also just, well, let me look at the other brief. Maybe they got it right, you know, for guidance. And you don't want that. But thinking back, to me, the writing process is so important. So you can't, for example, assume that what worked below in terms of how you brief the issue will work here. The standard of review is going to be the guiding premise, right, behind all of it. And so you got to take your time. It can't be like a 2-day deal. Don't bank on that. Right, you got to give yourself time, as the panelists who went through drafting the principal briefs talked about. It's a long process, and the more effort you put in there, I think the more it pays off. So just thinking back to how I handled things in the past, always try to buy yourself as much time as possible. And I say it that way because, you know, there's extensions, but sometimes there's internal deadlines, but just know your world, right? So that you know what the expectations are of you internally within your firm, so that you can crank out that first draft, and certainly know your court deadline, but give yourself enough time so that it's not just that you are, you know, cutting and pasting what was done below and try to fit it in here and making it work, because most of the times that's not going to work. You need to invest your time in that brief, because that's going to carry the most of the weight on appeal.
Okay. And I wanted to thank each of our panelists, a tremendous panel, had a tremendous seminar, and I think we're now ready to move over to the question and answer session. So I wanted to thank everyone, and then we're going to turn to some of the questions we've received from the audience. Bailey, do you want to pick a question first?
Sure. We've received a number of audience questions throughout this CLE presentation. Thank you all very much for your attention and participation. The first one I wanted to start with is for Lindsay, and it's about advice for reviewing a truly voluminous record on a tight deadline. And the person who asked it specifically with regard to criminal appeals, but civil appeals can often have extraordinarily voluminous records as well. So this is something that's really of general application. When you have a 39,606 page record and other things to do in your life, do you effectively review that, but also not spin your wheels and manage to get through it by the deadline?
Mm-hmm. Well, unfortunately, I don't know of any shortcuts other than I tried to present a framework that would help you move through it as quickly as possible. But if it's truly voluminous, you probably can't do it on a short deadline. But what you can do is, you know, go and identify in the very beginning those key documents, like, you know, if it's a criminal case, I think you said the verdict, judgment and sentence, the charging document, the closing arguments at trial, the key motions. If you read those up front, then I think, in my experience anyway, you should be able to move through all the details of the record faster because you have context for them. But I don't know of any other shortcuts, but maybe some of the other participants here might have some advice too.
There aren't any good shortcuts. Moving for an extension of time on that ground. And if you can't get it, then you do the best you can. And my
Mhm.
sense is you have to read it all if you possibly can.
Mhm.
Okay, then we have another question from the audience. Traditionally, the advice has been that if you're the appellant, you always ask for oral argument. I'll start with Judge Nordby on this one, but would appreciate Judge Osterhaus and Secretary Marciller and if else jump in. Is that still the sort of standard of care that if you're the appellant, you got 10% chance of winning anyway, so just always ask for OA?
Yeah, you know, when I was in the SG's office, typically we always asked for OA when we represented appellants, just because typically the issues were of such statewide impact that we knew if we went for it, it was likely that we would get OA. And typically it was just always helpful to have OA in those cases. And, you know, in private practice, it's more a conversation with your client and talking them through what's the, you know, what's the purpose of OA? Will it be helpful, and kind of include them in that to a certain extent, just so they know what to expect. I think, you know, that's traditionally been the advice, because as appellant, you know, you're coming in and there's that standard, you know, statement that trial court decisions come to the appellate court clothed with the presumption of correctness. And so you're already starting off as an appellant with an uphill burden. And why not seek that extra opportunity to have OA and make your case as best you can to the court? So, you know, I think that that's been the traditional advice for a reason, but I always like to, you know, think it through before I file a request for OA when I was a practitioner, and just make sure that in my request, if I'm going to request it, I'm going to explain why, if it's worth going for OA as an appellant.
Okay. Have some other people join in on that?
Sure, I'll just follow up. It's been a while since I've had to manage client expectations, but it seems to me that that counsel along that line and having as good and healthy and open lines of communication as you can with a client would be key there. I mean, some appellants are going to be bringing cases that are, you know, that are probably weak, and the lawyer may know that. I mean, there may be a chance of, and so they can make a good faith argument, but to in the process of counseling a client, process of managing expectations, okay, do we really want to spend time, energy, effort to do this? You know, I don't think you do it in every case.
Well, you know, and I sometimes took the opposite approach. If I was the appellee, I'd often ask for oral argument in cases that I thought had little chance of appeal. And it was just on the thought that if we have an oral argument, the court will come together and we can, you know, we can maybe get to the bones of the matter a little bit more quickly. So as you both said, there's a lot of different factors that go into it. Bailey, did you have another question you'd like to ask?
Sure. So another viewer asked whether, and I'm going to sort of rephrase the question slightly, but whether there was a way to overcome a problem with the record failing to include evidence that had been created by a witness during the trial, such as, and I guess this is mostly directed to Courtney and Matt, as far as, you know, the building the record and preservation issue. So let's say you have a witness who's marking on a screen where a document is displayed, and his markings or her markings are being simultaneously published to the jury. And they're, you know, testifying about what the marks mean and is using them to highlight information for the jury's say. But then that marked version of the exhibit is either not in the record or just straight up not preserved. That nobody bothered entering that marked version into evidence or preserving a copy of it in some readily accessible way in the record. Is there anything you can do about that?
I'll take a stab at it. You know, 9.200 has two different mechanisms for creating an agreed statement or reconstructing what happened at trial or at a hearing. They generally require agreement with opposing counsel. which in many cases is not going to be forthcoming. So the bottom line is it's a real problem. There are ways as an advocate you can try to get around that, and maybe you look for hints and clues in the transcript of what people were doing and sort of rely on that to support the inference that what you say is true, knowing the other side might be able to say it's not in the record, but they can't really deny it happened. But it's tough, and at that point you have a conversation with your trial counsel to say what happened.
Yeah, following up on that, I think Julie mentioned thinking about your OA as you're doing your brief, which is excellent advice. Think about your appeal as you're doing your trial. And there's really, I mean, you don't even think, I think sometimes when you're in a trial or, a witness's testimony is being taken and they say something one way, and then you read it in the transcript and it's like, oh my God, that is not what the way it reads on the cold transcript is so different than the way it sounded at trial. And so thinking about that when you're at trial, thinking about, if someone is silently sobbing in front of the jury and you want the record to show that for whatever reason, making sure that is clear. In this specific example, I mean, I agree with everything Matt said. It sounds like it would be a case where you'd need to agree to it, but making sure that if you have demonstratives, that they get filed with the clerk, or that there is some record that is taken of what they are, so that you can go back and not have those fights later. All the better for you. So take that advice to heart as you're going through these trials, because even if you're not handling the appeal, you will make your appellate lawyer a lot happier with you if you are conscientious about that the record reflects what actually happened during the trial.
And something we haven't touched on to any great degree in this session, but something that's really a huge part of appellate practice these days is trial support. And having an appellate attorney involved very early in the trial or even pre-trial process can make sure those preservation issues get nipped in the bud and don't rear their head later on when suddenly you need this critical fact and we can't get it. Russell, did you have another question?
I had a good question about how to fix FSU football team, but I guess we'll save that for another day. No, had a very good question. Obviously, there's some litigation matters, say child custody, maybe probate, that are at the trial court level very fact-driven, perhaps somewhat emotion-driven. When those kinds of cases come from an appeal, is it still the best practice to have a very objective, even-handed approach in terms of how you argue and brief the appellate issues? I think we'll let Matt take this one.
You just see me making faces as you're reading the question. The standard answer among judges and practitioners would, of course, be you should appear to be objective and be not try to play with the emotions of the appellate judges, because it tends to backfire. But here's the but. Appellate judges are humans, as Judge Osterhaus said earlier, and they react to situations and circumstances like people do. And so part of the art of appellate advocacy is to dial down the temperature of what was happening in trial court. A lot of trial court materials really are just hyperbolic and invective everywhere, and it's off-putting, especially at the appellate level, because the judges really don't want to see that. But that doesn't mean it should be stale and bland and not a story that has maybe good guys and bad guys and interesting to read and kind of evoke a reaction from the judges that somebody should be winning and somebody should be losing here.
Okay, very good.
Can I just amplify an aspect of that? I think the element of storytelling is so emphasized at the trial level and often overlooked at the appellate level. You need context. And so often that sits in the statement of the case, the factual background. There's a story to what happened during your trial. There's a story to whatever happened before you got to trial and what the facts are. Often there's a story to how you ended up with whatever the piece of legislation is. So when I was in the Solicitor General's office, legislative history is maybe out of style as an interpretive device, but there's often a story to be told about how those words got to be there that can be useful context, even if the court's not going to end up deciding based on that story. So I think, the more you can kind of create the story before you get to the legal argument in your brief, the more you can dispose the panel to see the world as you do, or at least understand why they might want to.
If I can piggyback as well, some very good advice I got just first day actually of private practice was, by the time someone finishes reading your fact section, they should know how you want them to rule. And second, they should be in favor of your client. And that doesn't mean name calling. It doesn't mean getting into the back and forth that happened at the trial, but it means putting forward the facts effectively, as Jonathan said, like the context, the background, so that you point the reader to where you want to get them to on law.
And I know we're run out of time, so I'll just ask this. Julie, would you recommend doing a reply brief in an appeal involving a non-final order?
Yes, inevitably, you're going to find things that you want to emphasize. It's your last chance to crystallize your points, to really nail it and bring it home, and oftentimes what I find is that if there's a difficult point that the appellee has tried to just circumvent, that's your opportunity to think of it this way. Your initial brief had to be a very long piece, right? Because it's your first story out of the bat to tell these three judges who haven't seen your case before. By the time you get to your reply, you can abbreviate and shorthand a lot of it and just get down to very much how you would be arguing it in front of them. And that, to me, when really just honing in on what the appellee has and has not said is critical, because if not, then what you're left with, and there's always something, right? There's always something that the appellee has said that may ring true for someone. You never know what nerve it's going to hit with one of these judges, right? But the worst thing is that you had the opportunity, right? Unlike with motion practice, you had the opportunity to file a reply and you let that just sit there, right? You let that appellee have the last word. And no, sir, no, you should. In my opinion, it's a really great tool to use. And again, succinctly, right? Because we don't want to overdo it, much like we don't want to max out our page limit with the principal briefs if we can avoid it. But the reply brief is that one last piece to remind them, here's why I'm right.
Plus, all the more so, making sure you shore up when you don't get an OA. You're probably not going to get an OA in a non-final appeal. I think a lot of the courts, as a matter of course, will not grant you one. So you talk about last words. I mean, it really might be the last words you get to say.
And I think we're out of time. We have more great questions, but I think we are out of time. So I'll turn over to Bailey to bring us home.
Thanks, Russell, and thank you all for being here with us today for this panel. This would not have been possible without all of our panelists' knowledge and their, of course, generosity with their time. Russell and I are deeply grateful to have had the benefit of that, as I hope our audience will also benefit from. Once again, the course number, for those of you who didn't get it at the beginning, is number 5534. That's 5534. And with that, we'll draw the program to a close. Thank you all for being here today and have a lovely weekend.
Thank you, everyone.